Mate, this matter is a public investigation stormotor by the Honorable High Court
Yes.
with regard to the road, national highway that runs up to the top. We are supposed to monitor the situation under your lordship's orders and file our reference to that. Now, currently, the situation as it stands is there are two particular stretches of this road. One is at a place called Baratang, the other is at a place called Ranga. These are the two notorious stretches where no work has been completed for quite some time, despite various efforts. Now, unfortunately, in Andamans, the situation is you cannot work beyond a certain time because of the rain. Obviously, once the monsoon starts, any sort of road work, it is condemned to disaster. So that working season starts roughly around now October, November, once the rains will stop, and it will continue up to April or May. Now, in this period of time, the NHIDCL, which is a special vehicle created by the Government of India, is supposed to do the highway. Now, in all honesty, prior to the rains, when we last inspected and saw the situation, we have filed the reports. There were certain stretches which were quite bad, but where work was supposed to be done and deadlines were, in fact, submitted by the authorities of the NH before the Honorable Court in person. They came and said that your lordship will get from the orders. Now the situation is
Dealt with this matter when.
yes, but for the benefit. Yes, my lord. This is still continuing.
It's still.
Still continue. And for the benefit of my lord Justice Rishidi, I'm just giving the background also. Now the situation as it stands, my lord, is Baratang and Rangat stretches horrible. We used to say there's no road, now there's less than a road. It's like a buffalo's walk.
These two areas have not been touched upon.
No, it has been to a certain extent. Some work they have been trying to do. Now they're finally, the lordship will recall those chemical processes they were doing. That has now been abandoned. They've gone back to the conventional road building techniques. But the problem is that the blacktopping, which we have been adopting as a definition of road, a complete blacktop road, that has not happened. So there is still 80 kilometers an hour, which has not been touched. And unfortunately, what has happened this time is they started work, but in the process of doing that work, they got tangled up in paperwork and all sorts of red tape over various sort of documentary issues, this permission, that permission, details, things like that. Now, with the result that between January to February, no real work could be accomplished. They will show reports where they will show in terms of percentages, but statistics can be very misleading. In actual honesty, the road is not there. Now, as it stands, the monsoon came early. Now, because the monsoon came early, now work had to stop in any event. Now the situation is very bad. The court has repeatedly passed orders saying keep it motorable, at least help vehicles to pass through, keep the lifeline open. So that is where we were sometime in June or July.
Especially we were concerned with the fuel carrying vehicles.
Fuel carrying was only one aspect of it. Ambulances were there. We were looking at LPG situation, emergency services, even daily groceries and basic essential utilities. Everything was a problem. Now, as it stands, in the last circuit, the court had, one of the last circuits, the court had said that whatever your administrative difficulties are there, please sort it out at this point of time, because now you can't work on the road. So do your paperwork. And the court had asked that the Chief Secretary's chairmanship, certain meetings would be held and all these things would be ironed out so that as soon as the rain stops in October, November, they can immediately start the work and hopefully things would move onwards. Now, in the last circuit, those orders had been passed and they were supposed to come back with reports. What is the current status? What is the work done? And the main thing is getting these meetings completed and getting those issues out of the way so that when it's time to work, they won't again have to run around with fights. Well, this is one part of it. The second part of it, which is the development since your lordship came last time, is that a bench of this honorable court, while here in Port Blair, had observed that this case is dealing with the NH4 and is dealing with the main highway. But the other roads within the city and town areas of Port Blair, which come under the APWD, as well as other islands, are also in pathetic condition because with the rains and non-maintenance, those are also damaged. So the Honorable Court was pleased to enlarge the scope of this so as to say that let the other roads of the islands also be looked at as part of this. Now, so far as that part is concerned, a report is also supposed to be filed as to what work has been done by the APWD and to take an assessment of what is the situation. And up till here, we have complied with your lordship's orders to the extent that whatever we were supposed to do, we have placed on record. Now, my learned friends are to.
You're supposed to monitor the entire situation, right?
Yes. Now, my lord, when your lordship was in the last circuit, my lord, at that point of
You're
time,
repeating for the
NHIDCA, yes. And at that point of time, there were certain issues with the contractors and all. Certain stretches were not, my lord, being maintained. That is, my lord, on record. We cannot, my lord, better the record. And my lord, some contractors were removed, and your lordship knows, my lord, litigation immediately follows. And bringing in new contracts and all, those took some time. Now, my lord, the best part is that now the entire stretch is either under the EPC contractor or under the maintenance project. The entire now stretch has been now under either under the construction work is going on or the maintenance work is going on. Now, there are certain stretches that has we have witnessed that due to this certain rainfall and all, the black topping we couldn't proceed because it will be a futile exercise. Yeah, as soon as we put it, it will be washed away. So what we are doing is right now we are working on the retaining wall, the guard walls and other works which can go on, the concrete works. And so far as the other paperworks are concerned, these we are now having, and with the administrations we are having regular interactions, and hopefully these things, the entirety of it will be completed in a couple of months' time. So on those part, there is no problem.
This will be completed in a couple of months.
Yes, because there are certain issues that we were facing at that point of time. The forest clearance, the bringing in the barges, and these took some time. Now, if your lordship wants, we didn't want to increase the paperwork and the volume of the reports filed, but the fact remains is sometimes were required because those are probably the statutory rules guiding the provisions of putting in an application before the forest department. The forest department looks into it. Initially, the falling of the trees was beyond the scope of the forest department. So we had to wait. The meetings was held, and we are regretful to officers because the meeting was arranged and everybody was on the table and everybody agreed that this work is has to be solved on the priority basis. So that work continued. Now, as on date, we have put in on report, as Mr. Kabir has pointed out. This is the engineering terms. We go by the percentile output that we give. Definitely in some areas we are lacking. That is definitely there on record, and in some we will achieve the target as we have pointed out, subject to the availability of the clear sky. And now lordship will appreciate the monsoons are unpredictable. Sometimes even during the monsoon period, we are getting clear sunny day, but that cannot we cannot do the work at that point of time.
Position to resume work as soon as the rain stops.
Yes, yes.
I mean, your paperwork, your official communications,
Absolutely.
formalities, all that is over.
This is, I cannot say over. That will not be a proper statement on my part. But we can say that it's in the verge of completion. Both the administration and our office, we can file and report to that extent. We didn't want to, this was my personal opinion, we didn't want to put the volume up because the reports are piling up and it's difficult for your lordship also to look into. Now, if your lordship in the next occasion, or even if your lordship wants it today, Mr. Kabir and Mr. Kumar had the occasion of taking a stock of the situation, I think in February or March. And then a detailed report was followed. So what we did was we took it as a guideline that these are the deficiencies that has to be addressed and these are the issues that has to be addressed on a priority basis. As your lordship pointed out, it's a lifeline. Flying of the vehicles is priority. Road, no road. One thing has to be ensured that the vehicles can fly from southern Andaman to northern Andaman with all the LPG, vegetables, whatever it is. Now, your lordship, in the meantime, what happened, there was an incident that a bridge, there was some difficulties. We immediately addressed, we put in the Bailey Bridge, we ensured that the vehicles were flying. So, these emergent works are being addressed by our officers and the engineers. To that extent, I can submit before this court that this part is there. Now, so far as the progress, so far as the blacktop, what a layman understands, that there will be a complete black road where the vehicles can go. But so for that part is concerned, that work can only be resumed after the monsoons are over. I cannot go beyond that. So what I beseech your lordship to consider that
But that is not in the Rangat and Baratan stretch, right?
the Angad
We have
Bara-
not reached that far. in
Yes,
these
yes, my lord.
stretches.
That when your lordship, when I was, my lord, assisting your lordship on the last occasion, those points, my lord, there were some issues with the contractors. The earlier contractors had an entire stretch. He couldn't mobilize the men and machinery. When he was working in A stretch, the C stretch has to be addressed. So he cannot, my lord, took his entirety and go and shift and address that. So now this part has been broken into, my lord, a small change, and this has been, my lord, retendered, and now, my lord, these issues has been addressed. So your lordships, my lord, if my officer, lordships officers also can, after the monsoon is over, take a stock of the situation, that what we have done so far, and thereafter, my lord, if another, my lord, report can be filed, we can look into, which we don't say that there has been any this thing progress, because we are working on the concrete and other parts.
There are certain directions given in the earlier order by this.
Yes,
court, I
yes,
find.
yes. That
The
report has
last
been-
two orders, your lordship will see. In fact, continuously from December 16th on, there are a set of orders which have been passed.
Yes. So that's what we were wondering, like passing another detailed order will really
Yes,
not,
my lord,
help. I
And
mean, these
even-
orders need to be complied with.
Absolutely.
Now, my lord, in all honesty, now while it's raining, we can't say anything.
Absolutely.
absolutely, madam. When there
Passing
is a-
orders which can't be implemented is not helping anyone.
yes, your lordship can pass an order if there is any emergency that arises, which my lord's officer brings before your lordship or any other, my lord, citizen, that that will be addressed, my lord, as soon as it is brought before your lordship. But so far as the regular work is concerned, so far the other directions is concerned, your lordship will have to appreciate the situation and grant us the time till the, my lord, we get an,
In a March
Yeah.
24 order, I find
yes,
a detailed direction was given.
yes, yes.
My lord would kindly see this document. This is after our meeting that was held. We had basically tried to bring everyone together, all the officers and all, sat them down to identify what are the issues, what are the problems. In this particular document, if your lordship kindly see, it's the second page, the critical areas discussed. Number one was Baratang, that 107 to 138. That has been retendered. There's a new contractor. But the issues faced at page 3, one of them was this barge issue, so that they can take materials. The second one, which is at page 4, was electrical utilities. Basically, electric poles and wires need to be moved so that the road can be expanded and work has to be done. Number 3 is the ferry, because since the barge could not carry materials, the ferry service had to be expedited so that more trucks could go. And number 4 was a forest issue. The forest issue was because there were 2 bridges which needed to be made. But while you are building the bridge on the main road, you basically have to make a diversion. So the road will come, go down into the forest, come back around, and then go again. But because you're making that excursion into the forest, again, trees need to be cut and all that. So for that, again, permissions were pending. These were the 4 main issues which we had recommended that they were dealt with expeditiously, because these are the issues which are standing in the way of the work once it can start. So
These issues are being dealt with.
my lord, so the court directed that let the chief secretary look at all these matters with the concerned stakeholder, and then and there, because rather than this paperwork where they write one letter, the file goes here, the file goes there, this court said let everyone sit at the same table. Now NH, say what your problem is. The authorities, AWD, say what is your solution. Electricity, say your solution. Forest, say your solution. And chief secretary will bring them all together into one harmonious sort of platform where everything can be sorted out. But I am harping on this. This is what needs to be done and completed. So that as soon as the rain stops, these 4 problems are out of the way, work starts smoothly and carries on. Now, this is so far as Baratang and Rangat is concerned. Thereafter, your lordship will find at page 8, we have dealt with the Middle Straits Bridge, which is the bridge for crossing after the Jaroa area from the Middle Straits into Baratang. This bridge has been under construction for 7 years. It was never completed. Now it has been retendered. It's been redesigned. So this bridge is one of the key components of the entire matter, because then once this bridge is in place, a lot of smooth transportation of materials and other things can be done. This is something which they had said December 2026 would be the end sort of goal. But this progress also needs to be looked at. Apart from this, my lord, honestly speaking, the other repair work that had to be done, that was all taken care of. So it is mainly Baratang Rangat and the Middle Strait Bridge. So far as the other places further north are concerned, around Mayabandar, Diglipur, Kadamtala, that side, there were landslides, heavy rain, those we have immediately intimated the NH through Mr. Sanyal. He has passed on to his officers, and I must say this, that wherever we have directly interacted with him and said this is a problem,
It has been taken care
they
of.
have addressed it. So they will rush their machinery, clear the place, get the road functional, those things, no doubt about it, doesn't done. The problem here is a permanent solution. So that in order to get that done, if those four issues stand resolved with these committee meetings, then my lord, I hope that in the next working seasons, these issues can be completed
Yes.
and work it done.
Well, so far as the administration is concerned, we have conducted those meetings. My lord, we request some time, my lord, might be on next week, my lord, we shall file a report that the outcome of the meetings and all. In those meetings, the chief secretary, the secretary power,
Was the meeting?
just after this report was submitted, the order was in the month of March or April, those meetings were conducted. But all the stakeholders were present.
March.
We have to also, my lord, file the report, my lord. Both the APWD and the PBMC are required to file report by way of affidavit, my lord. That, my lord, I apologize, my lord, that has not been done, my lord. We need some extension, my lord. That is in regard, not regarding the central issue of NHAI, but regarding the other roads in the islands. PBMC has given us a report today, but it is not in the form of an affidavit. So we need to file that, and APWD also needs to file two affidavits. One is regarding the general condition of roads in the islands, and secondly is regarding these meetings that have in fact been held, but under the aegis of the chief secretary with the NH authorities and also with the department here. So, my lord, we are requesting for some extension. My lord may grant us, my lord, 2 weeks or 1 week as it pleases your lordship.
Can you come back next week with the reports?
Yes.
You need.
My lord, we'll file it, my lord. My lord may grant us, my lord, 1 week. Only difficulty is, my lord, the panel, my lord, as in for the Wakalatnama, my lord, the panel expires on 1st of August. So, my lord, after that, there'll be some time during which, my lord, letters have been sent to the central government. So, filing, my lord, may be difficult in the next week, my lord, if the extensions don't come through, which is why I was requesting if my lord grants us 2 weeks, then, my lord, it would be better, my lord. Otherwise, as your lordship.
My lord, that is so far as the roads are concerned.
Yes.
My lord, so far as the other pending issues that we have brought into the administration, to that extent, my lord, a report can be filed. That what are these stages like
The
where
meetings.
meetings. Because my lord,
The
we have,
meetings and the conditions of roads, these are the two issues which the administration has to,
yes,
yes, has to address.
APWD.
So, Learned Council wants to come back with both the reports after 2 weeks. Because there's an issue of his extension, I think. So
Yes.
let us keep it after 2 weeks.
But
Because unless he's able to sign the Wakalatnama, I don't think he'll be able to.
Mr. Rakesh.
Yes, my lord, my advocate on record, my lord. That's right, my lord. I'm an advocate on record as to sign.
What I mean is he cannot appear unless that is done. And he's not independently doing it. So he's assisting with Chakravarti. So yes.
So, my lord, the same problem will be there for all the panel advocates, my lord. Extended, I accept Mr. Sivabalan, I think he has some more time. Other than that, everybody will have that problem, my lord.
Let's see, as and when we face it, we'll deal with it.
Yes, my lord.
Only reason that I have raised all this concern is that we are already heading into August. By September, if all this is out of the way, October, let them hit the ground running. Otherwise, another year. It's now, we kept saying, when your lordships came last time, we said 6 years, no work done. Now it's 8 years. And that road is still not.
No, there's no doubt that the work has to be done, my lord. That this is only on the procedural part of filing the report, my lord. Work has to be done, my lord. There is no doubt about it.
2 steps forward during the working season, then the monsoon comes, it will go 4 steps.
That is exactly what is
That's what
happening.
is happening for the past 6.
So it is expected that before the next monsoon, everything is over. I mean, it's completed.
We have already given some deadlines by which we complete certain places. And yes, that Mr. was pointing out, that was from the initial stage, that's problem we are there. With that posted, now she has said that not posted, we are posted.
We are starting from, we are scared of for an inspection. If you could not right on that road, what we are getting the information very well. Some of our advocates are traveling from Ireland for cases. Some of them are regularly moving up and down. the road.
It's very
Advocates are
difficult.
saying,
We understand,
Don't,
sir.
don't dare to venture in that. That my lord officer feels if our notice pilot to immediately address, that is always there. Immediately address.
Report submitted by the joint special officers is taken on record.
No, but.
No, today's report? Oh, this is your report. Submitted by the NHIDCL. Oh,
That's fine, yes, it's.
it's taken on record. Paragraph. Learned Counsel, the joint special officers represented by Mr. Kabir submits that in a meeting held by and between all the stakeholders on 22nd March 2025, 4 principal issues were flagged. First, the Baratang section -107 to 138 where there has been almost no progress in construction of the road, more so due to the monsoons. Second, the electrical utility shifting which includes shifting of electrical wires, cabling and utilities, so that the construction work of the road is carried out smoothly. Third, the ferry issues which pertain to carrying material up to Baratang from Port Blair. The damaged bridges have been restored by now, right?
Yeah.
This court is informed that the material are being carried up Baratang through the bridges at BD Nalla and RK Nalla, which have now been restored. The fourth issue was with regard to diversion of the road connecting
There are two cases where the bridges.
for
Package 3.
construction of bridges at 119 and 122 chainages within package Roman 3 capital A. These bridges are yet to be constructed.
For that, they have driver around into the forest. So that's forest area diverted.
For construction of the said bridges, a diversion through the forest area is required, which shall entail probable cutting down of trees.
No, this is all been described in detail to the report in page 6. The 4.
Yes.
4B, in December 24, an inspection was done that made a detailed report of all the trees. 27 December, a meeting was held at Rajnivas with the Minister of Road and Highways, with the government and others. was equally agreed by the principal chief officer of policy. We give you 3 months temporary. Then that request went through and until there was 6.5. On 25th of February, the minutes were amended because assistant consulate. We've given you permission to work, but we can't cut things.
It cannot be done, cannot be done.
Again, a letter had come saying that diversion can't be done because you have to do this through the ministry, go and apply online. Because this was one of the things which the court said the executive will also look at. Because actually, I think a number of things when we consulted them, it came out to only 13 or so. So if these are dealt with, you make the online application with the explanations keep happening. It's paper law, nothing else. So that part of it was also supposed to be dealt with in those.
The subsequent meetings
These meetings are supposed to have held after the report was filed.
after the report.
And now we are waiting for the reports of those meetings to know what happened to the meetings. Those are the ones that out of the way right now. If these paperwork are finished, then those bridges can be built as soon as the bridge is finished.
In order to deal with the said issues, direction was given to hold meetings with the administration, right?
Chaired by the, under the aegis of the chief secretary of all the stakeholders.
Of
Administrative.
all the stakeholders, including the administration and other authorities, in order to sort out the issues flagged in the earlier meeting. Such meeting, this court is informed, has been held. Stop. The administration seeks time to submit reports with regard to the decisions arrived at in the said meeting. It is pointed out by learned counsel that the stretches of roads at Baratang and Rongot are in extremely deplorable condition and are not motorable. They cannot be used even for emergency services. Paragraph, learned counsel for the NHIDCL submits that the work has been stalled due to the monsoon and is expected to resume immediately after the monsoon season, right?
Project is in entirety.
Has slowed down
Yes, yes, my lord. I'm grateful.
instead of stall, make it slowed down. However, it is not in dispute that the maintenance work, as and when required, is being done by the NHIDCL. Paragraph. The present application has been extended by this court to maintenance of the roads in the islands. And a report was called for with regard to the present condition.
My lord, every month, my lord, pursuant to your lordship's directions, my lord, we are to file the progress report.
And progress report has been called for, indicating the stage of work as well as condition of the roads in the islands. Paragraph. Upon consideration of the submission made on behalf of the administration, the NHIDCL, and upon hearing the special officers, comma, it can be held that the construction work shall be resumed in full swing after the monsoon season. Stop. The issues flagged by the authorities can be expected to be sorted out by and between them in the meantime, so that the actual construction work can resume immediately after the rains cease. Paragraph, since Learned Counsel for Administration seeks accommodation to submit reports with regard to the meeting held between the authorities and the conditions of the roads in the islands. These are the two reports that you want to come up with.
Three reports, my lord. One, certain roads of the island are maintained by the APWD, certain roads in the island are maintained by the PVMC, which is now SBPMC. So, my lord, we shall file two reports for the road condition of the island and one report for the meeting. So, in total, three reports we shall file.
Make it. Authorities slash reports and the condition of the roads in the islands. Such report be filed within 2 weeks?
Hello.
Within 2 weeks from date. The matter be placed before the next available circuit bench. A further report be filed by the NHIDCL
Man,
indicating the progress in construction.
Great. It will be my lord pleasure to indicate, because the last circuit bench indicated that it will appear on the second. Generally, my lord, there was a direction that it will appear on the first date of every available circuit.
Let it be on the first day, that
Ma-
means, let the matter appear on the first day of the next available circuit bench under the heading to be mentioned.
Great.
Great.
Next.
My lord, I'm appearing for the respondent, but we have not received a copy. If it can be served, then to Mr. Rakesh Kumar.
Paper.
Borrowing my words, I was about to say, here said, on record with a copy to the rest.
Lordship, in this matter, today only we have filed our wakalatam on behalf of the respondent number 5. Lordship, I pray let the matter be next circuit bench, Lordship.
So since they are making appearance for the, Mr. Tabrez used to appear for the response for whom Madam appears now. Next week, this can be taken up more. Sir, B24,
But they also required to have the paperwork.
that I'll take care of. That I'll take care of. I'll take care of.
Next week, several matters have been fixed at your instance, actually.
As Monday, as of,
You want to come back next circuit?
Next circuit, Lordship.
as.
Paper books are filed. Your call,
Respondent number 5, Kumar Mohammed.
Mr. Chakraborty, next circuit.
No difficulty, as your lordship
No, for
deems.
the 1, 2, 3.
Yes,
Admin-
administration.
Nice.
You are for 5.
Eight lordships, sorry.
4 to 7, 9, 8, 8.
Will you not be ready next week?
Lordship not possible.
I think Mr. Chakraborty will also have some difficulty.
Yes. Yes.
My lord, because of the panel thing, otherwise whenever your lordship pleases, my lord, there is no.
That also needs to be taken care of. I mean,
Yes,
otherwise,
my lord, we will not be authorized to make submissions, my lord. The problem will arise, my lord.
on prayer of the 8th respondent, comma, the matter be placed before the next available circuit bench.
Appearance will be.
Yes.
Great.
Your Lordship, I am for the petition. I have not for the disposal of the matter, Your Lordship. So the third round of litigation, which was filed before the tribunal, it was filed in 2023. Thereafter, if Your Lordship would see the records, the order sheet, Your Lordship will find that 2 times admission has been done, 2 times, Your Lordship, for the readings are completed, that has been recorded. And then, Your Lordship, several times due to paucity of time, the case has been adjourned. So I pray that Your Lordship direction may be given to the tribunal for expeditious disposal of the matter. And Your Lordship.
It's a new matter, right? If not served, it's a new motion.
New motion. Service is complete. Service is done.
Service is up.
Affidavit of service also I filed.
Anyhow, we won't come in the direction of speedy disposal. But later service be.
Served on the, there is there affidavit of service?
Affidavit of service is not there, but I have got the. Let it be, Your Lordship, I will file affidavit of service.
The private respondents are also served.
Yes, Your Lordship. All, these things are there.
Haven't you come back tomorrow? I'll pass.
Yes, yes, yes.
They are only asking for speedy
Yes.
disposal. We don't have any.
Track report, track report should be
Track report, Your Lordship, it's very difficult to get, Your Lordship, nowadays.
only postal receipts will not help.
Then let it be on Monday, Your Lordship.
But may I not say one thing?
It's
Well,
only the prayer for expeditious.
Yes, yes, that election, they will be prejudiced, my lord. So that's why.
Your Lordship.
Great. एक कॉपी खाली मैं हमको हम लोग लेके अरे ये क्या बात हुआ उसका काम है
Expeditious disposal of OA 351. This is the number. 455 of 2023.
Yes.
Since the innocuous prayer of the petitioner is for expeditious disposal of OA number 351/455/2023 pending before
Central Administrative Tribunal.
the central administrative, but the tribunal is not operative throughout,
But Your Lordship, they come in circuits,
every month.
not every after 2 months, Your Lordship.
Even-
Next circuit is in September. Next
Even
circuit is in September.
even otherwise the sit in Calcutta is virtually it's available.
Yes,
Not like
virtually
that
it's
is not
available.
available.
It's available
Yes,
throughout,
yes.
Throughout the year, virtually it is available.
pending before the learned central administrative tribunal, Kolkata, the matter may be disposed of even in absence of the respondents. Stop. However, you are for 1 to your exponent numbers 1 to 1 to 7, 1 to 7. However, our respondent numbers 1 to 7 are represented. Paragraph. In view of the fact that the matter is pending before the tribunal from 2023, the learned tribunal is directed to take the proceeding to its logical conclusion I think we cannot fix a time frame that has been decreed. Will 2 months be sufficient? Yes. Let it be 3 months. As expeditiously as possible, comma, preferably within 3 months from the date of communication of the order, comma, in accordance with law. Disposed of? Next.
Section 5 needs to be taken up.
Have you started?
My client has only been served with the section 5 here.
Because appeal memo, I cannot do it unless it's admitted under order 41 rule. Like second appeal, not, they have no right to audience so far as appeal is concerned.
But since there's a section 5, they have all the rights now.
If Malad
If it
directs,
was
I will
within time,
if Malad directs, I will
if
serve.
it was within time, then it could have been done.
I'm giving here and now. I'm giving here and now.
I don't think, we don't think you're opposing.
Because there is a delay for more than a year, I believe.
It's 60 days, mainly on 2 counts, Malad. There is a bereavement in the family members. I filed a death certificate, and my client, Mr. Hridayanayan, was suffered with a brain hemorrhage. Malad would see the medical documents annexed with section 5, death certificate. So these are the main sufficient cause why I am being prevented to take out the second appeal within this limitation period. That's the reason, Malad.
Some distant relative has died. I can see from the,
Why don't you fight it out on merits?
yes.
Let it be allowed. Fight the appeal out on merits. Lord. Section 5 is, this is, can. The appellant seeks condonation of delay of 360 days. right?
Yes, Malad.
360 days in preferring the appeal. Paragraph. Learned counsel for the appellant submits that the delay was caused due to twofold grounds. Stop. There was a bereavement in the family. And also, comma, the appellant suffered from
Brain hemorrhage.
a brain hemorrhage. Paragraph. Heard learned counsel for the respondents. Paragraph. Upon consideration of the application made on behalf of the parties, this court is of the view that sufficient grounds have been made out by the appellant in explaining the delay in preferring the appeal. Stop. Also, comma, it is right law that an application under Section 5 of the Limitation Act ought to be construed liberally, and it is desirable that a matter is considered on merits and not dismissed on the ground of limitation. Paragraph. Accordingly, can such and such is allowed. Delay in preferring the appeal is condoned. Yes, let us hear. Yes, please.
District Judge, Andaman and Nicobar Island, early morning. By modifying the island without such and goes in appropriate stand as per standard and 1899. Thereby rendered judgment was unexecutable and unenforceable under law. B. Whether the first judgment under district or in not passing the institute judgment or exception partition commission report. It was to 22 and 4/3/2024 as its integral part of the now executing the pivot legal issue owned by record and should that is not enabled but partition by its bounds in terms of its degree path for the record since the applicant who gets higher value having a standing question about the chair portion in the partition commission report in favor of respondent for the respondents who get lesser value are entitled for money income in the form of equity. Whether the first chapter of the district judge for third exercising the power to appoint partition commission during the pendency of first appeal. In absence of any substantive provision of court of procedure 1908 hereby not conferred in the law by curtailing the right of parties to the first appeal to raise to be reports of partition commissioner and during the pendency of the appeal. Ignore this is first chapter the district judge heard in law. Passing the judgment by reading the inadmissible reports of partition commissioner dated 22 and 4/3/2024, which on its face translated and defeated the preliminary decree, by virtue whereof it has been held and declared that the trial court while effecting partition of the suit scheduled land, the partition commissioner shall consider and take into account the possession and convenience of the parties to be sued. E. Is learned first appellate court under district judge Andaman Nicobar Island by passing the impugned judgment of the decree transcribed the settled proposition of law as laid down by the Supreme Court of India that the degrees in partition to directs possession of parties to suit shall be respected as far as possible. Then it is mandate that as far as possible, the person in possession, appellant herein, of the property shall be permitted to retain his possession by means of acquisition of shares by making payment by party having greater value, which on the other hand protects the interest of party. Respondent herein out of possession for suit land having lesser value. As lordship, whether the learned first appellate court under district judge Andaman Nicobar Island heard in law in passing the impugned judgment of the decree by accepting the lordship, the same lordship, then
Yes.
I will not speak. But these are the substantial question of law. But what has happened?
What is the issue about?
What has happened? The partition suit was filed. I am the defendant number 2. So far as preliminary decree declaring shares, I have not been prejudiced. So the trial court on partition commissioner being appointed drawn the final decree. Even I am not prejudiced. The plaintiff preferred first appeal. But before the first appellate court, the commissioner again was appointed. Partition commissioner again appointed the first appellate court. 2 reports were called, based on which the final decree drawn by the court was substituted by accepting the report of the partition commissioner held during the pendency of the appeal. Mainly 2 substantial questions of law I would say. Firstly, Lord, the preliminary decree records that while effecting partition, parties' possession and their compactness for the suit land needs to be maintained. I have brought the judgment of Supreme Court which says if that is the clause in the preliminary decree, then lordship, as far as practicable, the partition commission must see that party who is in possession may not be disturbed, rather retain the possession, and the party who cannot have the possession of the property can be paid in terms of money. Now the portion which I am occupying, Hridayanarayan is occupying dwelling house, there are structures standing thereon. In the report so called for by the first appellate court during the pendency of appeal, that portion has been earmarked for the respondents. The Supreme Court said, in such a case, this needs to be taken into account. Possession needs to be protected. But a partition should these sort of decree, preliminary decree, mandatorily record this thing, because the person who is in possession may not be deprived of the possession, and the person who is not in possession must also not be deprived, because in terms of money, or that's what OTV can be given. I brought that judgment. This is first. Secondly, Lord, final decree cannot be executed because an execution is presently, unless it is embossed in a stamp duty. I brought that also judgment, Lord, which says unless it is not and it can't be executed. Mainly on these 2 counts, I've taken out this the second appeal. Now, I have a good case for arguable case, Lord. So far as these 2 questions, it goes to the very root of the matter.
May I submit it? Totally incorrect submission has been advanced. I never preferred, I was the plaintiff before the trial court. Preliminary decree was on consent.
Yes, that I find.
Yes,
Yes.
it was on consent. So there was no chance to prefer any appeal. When they preferred an appeal, I raised the preliminary objection that this appeal is not maintainable. Then the honorable court said, see, it is between the brother and sister. Whatever his grievances, kindly, I am suggesting to appoint a commissioner
lower court's commissioner report, we will forget it, we'll freshly appoint a commissioner. So I agreed. I said, okay, she's suffering a lot, so let the commissioner be appointed. The commissioner was appointed. And then they said that some portion which is lying in his possession, which is access to his original allotment, has been brought into the commissioner's report. Therefore, they raised objection with regard to that commissioner's report. And court said, no, I am accepting it. Then thereafter, they challenged it before the Honorable High Court. There was also an order, and finally, Your Lordship, that was a consensual order, what was passed by the Honorable District Judge.
Where is that?
Let us see the Honorable District Judge's order.
Takes the memo of the balance. The very first judgment, I've not paginated the certificate copy of the interim judgment.
No, you cannot.
It's dated June 2023.
Page 15. It starts from page 15.
The first page is the trial court's judgment. Oh, the earlier one.
Not looking at
Page
them.
15.
That let me tell you.
May I please-
I'll just read the relevant one.
or to find the relevant part. At page 19, decision with reasons. Return to page 5 of the judgment, running back to 90.
The entire thing is to be ready.
We can go in the room, just as requirement, that's what it.
You accepted the commissioner's report before the appellate court.
Appellate court also.
Acceptance, not giving consent of law is no consent, no notice. Not giving consent of law is no consent. Not when the preliminary decree not should clearly records. Not that the possession of the parties to be maintained. Then not should, it hardly matters not should give consent. It's not should, can't be a consent in law. Because I'm not prejudiced by the preliminary decree. I'm not the prejudiced with the final decree drawn up by the trial court. I'm not prejudiced with the report submitted by the before the trial court, based on which the final decree was drawn up. This is for the first time, before the first appellate court, this exercise was undertaken. The exercise to call for the fresh report was done for the first time. So I've taken this point, my lordship. That's a part, not kindly appreciate. Have a look at the preliminary decree once. Now kindly have a look at it, my lordship. I'm in possession, my lordship, that needs to be respected. There are plethora of judgment on this issue. Not, I brought one.
I can bring those reports also.
We are on admission,
Not,
right? Not on the hearing of the appellate.
Lord, see, 32 page 32 of the memo, Lord, the decree of the trial court, the preliminary decree of the trial court. But parties to this suit are allowed 3 months time to effect the partition of the suit property, saying the plaintiff shall have liberty to move the court for appointment of commissioner to make the property partition by means and bounds mentioned as existing possession as far as practicable, but within the ambit of their shares. Now, this phrase, existing possession as far as practicable, has been interpreted by the Supreme Court. There should be party in possession and in a partition suit, if the situation is so proper, and should the court ensure that his possession should not be disturbed.
Yes.
Rather, the adverse side must be compensated in terms of overty.
And you say that that part of the property has been allotted to,
And that has been accepted by the first appellate court in the report itself. The report which was called for the first time by the appellate court, which was substituted by the trial court's report, records that my possession would be given to the respondent. So I've come up before this court in the second appeal, not.
so that is an arguable issue.
No, Your Worship. It is not so. Whatever my elder brother said, where is the document to show that? From the report, it is very much clear that his interest was protected. Even his construction was never disturbed by any means. Absolutely incorrect submission is been advanced.
You are referring to the commissioner's report
Where is
placed
the commission?
placed before the appellate court.
No, that was called for, yes. That was called for by the district court.
You are aggrieved by the said report.
Yes,
right?
yes.
Where is the report?
Not any to the, I can bring it. I can bring it because memo contains these papers have annexed it, I can bring it. I'm not the advocate on record before the trial.
With argument even.
Because you are primarily aggrieved by that.
Absolutely. I will bring it on record.
Lordship, please.
I will.
The impugned order
I will bring it on.
from the judgment,
bring
it
it
should
on.
reveal. He has not even argued that such thing is.
Substantial question of law is a law.
No.
Question which is beyond the question of law. Not kind of appreciate it.
Before the first
Particularly-
appellate court,
Have
he
you
would have
recorded-
argued that.
Have you recorded a demand against the report before the first appellate
It was
court?
not given, that's the thing. Report was called for, the first appellate court passes a judgment based on the report. The parties should have been given a time to take an exception to the report, my lord. These are the matters. And particularly when the final decree was drawn by the trial court based on a report.
Let us see when was the report submitted, which was the date? And let us see the judgment
So
date.
I'll bring the report, not kindly consider that.
It reflects from the very judgment itself under challenge. When was the report submitted? Which report they?
4th of March 2024, my lord, kindly during the pendency. 4th of March
So who is-
2024.
Who has 20th June, the judgment has been passed.
20th June was passed.
April,
Report. Entitled to the very exception to the report. I'm asking
it be reflected in the judgment itself that you have raised any objection with regard to that.
myself of no consent, settled law. But I don't dispute this. They have every right to it. But what has been recorded in the
Recorded that you had no objection to the report.
Yes,
that was taken a ground. No, I cannot be concerned about that. It's because I cannot go beyond the preliminary degree. Can you appreciate that? I cannot go beyond the preliminary degree.
it is not a case to be admitted at all.
Beyond it.
It is recorded in the first appeal appellate order that you had, you did not object to the report, and that's why this order was
Yes.
passed. Please see the,
I've seen it.
basic-
I'm being for the first time. I've seen all of it was not. The point of argument. If I give a consent, which is no consent, would it be a binding upon me? The preliminary degree says, Your Worship, that my possession would be maintained in terms of the dictum later of the Supreme Court. But I can appreciate this.
it's also recorded that it's as far as, please read the. My brother has pointed out, very pertinent.
As far as April practicable, but within the ambit of share, you have exceeded your share.
This the first appellate could have not addressed this issue, not kindly see the entire judgment, not in the last judgment, it's no record. It is not addressed this way. The first appellate court no mention.
Everything reflected in the report.
I will pay for worship, for proper adjudication of the experience. I will pay.
Please come back with the report.
Leave me kindly. I can take it.
Let him come back with the
Fine.
report. Can is dismissed. After that, in SAT, on prayer of appellant, leave is granted to use a supplementary affidavit. Annexing copy of the report submitted by the commissioner before the first. When will you come back again? Why? In fact, Saturday is a working day. You come back on Saturday. Second August is the
wanted to be.
Yeah, big, this is on Saturday.
I have some difficult.
Court.
Some case has to be.
We have to fix some-
So that's what it happened. But the private respondent.
Official response.
I just give background. It's a some checker district.
There is a can, what is the application?
If you order that, then the private respondent vendor instituted a proceeding against present applicant's wife, Jayanti, before the consular office seeking an election. Lord, under the special regulation which is prevailing in the Tahsildar with the authority. The summary for proceeding. It would hold an inquiry. Then it comes to the person, owner of the property has to process within a year. Years, he would pass an eviction order. Tenant, that owner, he approached the Tahsildar. My wife, against my wife, eviction procedure was drawn. Then it was not given effect to the private respondent approach this on invoking finally, the intervention of my wife was evicted from the land of the the appendix. He is adding just to the land of private. He purchased it. Same officer during the year 2019 put appellant into possession of my recorded annexed the possession certificate before the court. Lord, as there was a disposition because this time the private respondent who purchased the property from her vendor Tahsildar paid. That since has been evicted, now the husband have occupied it, kindly pass a law. Tahsildar, at the first instance, under regulation of 66, that it because it has to be done within 2 years, not statutory. Now the private respondent appealed before the subdivision. The subdivision officer allows the appeal and Tahsildar comes to that order, passes the second time an order. That second eviction order, which I have assailed before the writ was passed without issuing a notice. Well, apart from these facts, there are one more fact. Worship, the present plaintiff approaches civil court for a decree of permanent injunction insofar as his property is concerned. Because both the properties contribute to each other, he had an apprehension and another apprehension by the revenue officers, active private respondent that he filed a suit for decree of permanent injunction insofar as his property is concerned. Suit ended with dismissal. First appeal lost. Before this court, second appeal, initial. This is the third fact. The matter was taken by Tahsildar after the order being passed by the subdivision officer. The subdivision officer at the first instance issued no notice, hearing nothing, but it was on a fine day passed order on 22nd April 2021. But in the impugned order, it simply records what the proceedings held in respect of the property, either in the court or in the civil court. No reasoning assigned, no notice of hearing it. I approached the writ court. Now, the writ court by the order dismiss the writ. I filed this intra court. I'll just show you. Can it takes up the stay application? Stay application note.
Page.
Page 93. Entrance to page 93. Yes. The impugned order is page 164. And actually, It's an order dated 29th April 2025. I think the read against the respondent authorities, more specifically against the respondent for quashing and for resigning and of considering the order dated 22/4/2025 as filed by the respondent of the authority whereby and whereunder the respondent authority has passed an order for vacating the authorized occupation of land bearing survey number 34/1 of the 40 1 of the 40 at Lambaline Village under Street 25. In course of the submission, Mr. Jayapal, that the secret advocate appearing on behalf of the petitioner at the very outset, that this court has that the present petitioner is in full occupation of survey number 34 of the 1 of the 15 in the self-same village, pursuant to the deed of sale as executed 18/2015, a copy of which has been annexed at page 25 to 43 of the instant petition. It is purpose submitted that from page 44 of the instant petition, it would reveal further that the name of the petition was given in respect of the said plot bearing 7/34 of 150. It is further submitted to Mr. Jayapal that since the petition is plot bearing survey number 34 of 1 of the 15 is equal to plot bearing 34 of the 1 of the 14, the petitioner reasonably apprehends that by dint of the challenge dated 24/2025, the petitioner may be evicted without due force of law by the respondent of the authority for which the instant petition has been filed with the prayer for passing interim order in terms of prayer number Roman 5 of the instant petition. Advocate appearing on behalf of the private respondent, our contest that the writ petitioner has not approached before this court with clean hands. It is submitted by Mr. Prashant that the writ petitioner is actually in forceful and lawful possession in plot bearing survey number 34 of the 1 of 14. And the same would be evident from the copy of the judgment dated 27/2024 as passed in OS number 18 of 2021 Shri versus Srimati Sarla Vidya, disposed of by the London Civil Judge Unit Division First Court Blair. Under it is submitted by Mr. Prashant that from copy of the judgment as passed in OS number 18 of 21. Reading the writ petitioner's contention as plaintiff that possession of plot bearing survey number 34 of the 1 of the 40 has not been considered favorably, which is why the said suit was dismissed and challenging the said judgment. The petitioner being granted to title appeal number 5 of 2024 before the London District Judge, but the said appeal was also at this time Mr. Prashant and advocate appearing on behalf of the private respondent also draw attention of this court to page 93 of the petition being a copy of the order dated 18/3/2025 as passed by the division of this court in SAT number 2 of 2025. It is submitted by Mr. Prashant that while dismissing the said second appeal, a division bench of this court came to a definite finding that plot bearing survey number 34 of the 1 of the 15 is under occupation of one Matthew Joseph. It is submitted to Mr. Prashant that the contention of the petitioner that he is in possession of bearing survey number 34 of the 1 of the 15 has got no legs to stand on. It is further submitted by Mr. Prashant that there cannot be any justification with the order dated 22/4/2025, inasmuch as the said order is very speaking and in such order reference has been given in respect to disposal of aforesaid title suit, title appeal as well as second appeal. Mr. Advocate appealing for Andaman administration, while supporting the contention of Mr. Prashant, draws attention of this court Regulation 28 of Andaman and Nicobar Island Land Reforms Regulation 1966. It has submitted on behalf of the Andaman and Nicobar administration that under said Regulation 28, the order passed by the Tahsildar is an available order. It is thus submitted by him since the repetition and the litigation is already remedy, the instant repetition is not maintainable. It's not maintainable. This court has previously gone through the entire as placed before this court. This court has also given consideration of the submission of granted advocates for the contending parties. Coming to the actual aspect of this court finds when passing the order dated 22/4/2025, the respondent number 3 has passed an order for removal and for vacating the unauthorized occupation of land bearing survey number 34 of 1 of the 14 situated at Lambaline Village under Sri Vijayapuram Tahsil. No materials could be placed on behalf of the writ petitioner that the writ petitioner is actually in occupation of the said plot bearing survey number 34 of 1 of the 14. So it has been contended by Mr. Chapal, advocate appearing on behalf of the writ petitioner, that since the writ petitioner is in occupation of contiguous plot bearing survey number 34 of 15, and there is every apprehension of his client that he may be evicted by date of order and challenge is no in such summation, inasmuch as in the order dated 22/4/2025, this court finds no whisper that the response number 3 has passed any order for eviction of unlawful occupant from plot bearing survey number 34 of 115. Other materials to be placed before this court by the witness to substantiate as to how his interest is going to be prejudiced on account of passing of order dated 22/4/2025. As rightly the advocate appearing on behalf of the private respondent that they are submitted before this court that not actually not in occupation of plot bearing survey number 34 of the 1/15, and such finding has been arrived at after conclusion of the trial by the jurisdictional civil judge, and which has been confirmed with title appeal as well as in second appeal. And further, while disposing of the second appeal, a division bench of this court a definite finding that in the plot bearing survey number 34 of the 1 process is in occupation of the plot. In view of the discussion above, this court finds that the petitioner has miserably failed to make a case to get any favorable order in absence of any material that he is either in occupation of plot bearing survey number 34 of the 14 or in plot bearing number 34 of the 115. On careful consideration of the order dated 22/4/2025, it does not appear to this court that the said order in any way fit. On contrary, it appeared to this court that the respondent number 3 has passed an elaborate reason. This court finds publicity in the order challenge. This court finds that the petition is merit and the same is thus dismissed. So this order I have said. But the order of the Tahsildar dated 22/4 not reached to into that. The tenor of the order not reached to 21. How this came to be passed? Page 19. Page 99 of the stay application. Sorry, page 101. Page 101 of the stay application. This order was challenged before the writ court. What would see the one-page order of the Tahsildar at page 101?
Yes.
What would see it's under regulation 161 at the top, just below the order. I'm just raising it, Lord. The records what has been done in the court proceeding, nothing, no reasoning assigned. Whereas an order passed by under in RC number in matter of illegal occupation of land survey number 34 of the 40 area 200 square meter situated at Lampaline village, being opined to the parties that section 161 of the Andaman and Nicobar Islands 1966 could not be applied due to lack of information about the period of disposal, which is mandatory under the said regulation provision, and the matter will be decided by civil court under section 86 of the said regulation. Whereas being agreed by the said order 11/7/2023, the appellants in the Sallah Bhatia by filed an appeal by FRA number 4 subdivision of 2000. And whereas the subdivision officer FRA in so after hearing the matter disposed of the appeal and reversed the order dated 11/7/2023 on 30th May 2024, and director Shaktivel son of Subaya illegal occupation land belonging to Srimati Sapla Vaidya within 1 week from the date of issue of this order is by 6/6/2024. Whereas being aggrieved by the subdivision order dated 30th May 2024, Shri Shaktivel son of Subaya Lamal goes the junior division by OS number 18 of 21, which was on 27 to 2024. It 5 before the London district judge, PA number 5 was dismissed from 24 to 2024. And whereas a further appeal before this Honorable High Court at 2 of 2025, and another was dismissed from 18 to 2025. And whereas 30th of Andaman and Nicobar Island regulation 1866, all land in Union Territory West government and no person shall be killed for the acquired any right herein by occupation, prescription, conveyance, or otherwise except by conveyance executed by under the authority of government. And whereas your continued occupation, that land is unauthorized, illegal, and untenable, and you are liable to be evicted under section 160 of the regulation. Now, in exercise of power conferred upon me under section 160 of the Andaman and Nicobar Island Land Revenue and Land Reform Regulation 1966, I hereby authorize Shakti Bedi son of Subaiya residence number to vacate unauthorized occupation of land bearing survey number 24 of 40 situated at Napala and Vijayapuram on or before 2025. Failing which the same will be evicted by revenue authorities before or after May 2025 without further notice. So this in view of the came to be passed by the Tahsildar. I'm just giving not 5 months to take 9.
You came to be in possession of 15 or 14.
I'm the owner of 15. It's contiguous to 14. It's contiguous to 14. I'm being put into possession during the year 2019 by the same Tahsildar who passes an order.
In 15.
Yes.
The property dispute at all.
Not at all. Not at all. But since the property is adjusted to my land, not to see this eviction order. It is addressed to me, not to see page.
Eviction is from 14, not 15.
Not true.
Eviction is not touched upon.
Not true. But the thing, kindly appreciate one thing. Kindly see page 101. 101 at the bottom, it is addressed to my client. This is addressed to my client. Not they are trying to speak from 15. I'll just show the order of the subdivision officer. I understand. All related topic. But my apprehension is well founded. There are concrete substance before the report to demonstrate. The basis of this order, they are trying to dispossess me from my recorder, and I'll show that. The same Tahsildar who passed the order on 22nd April 2025, who turns to page 98A. Same Tahsildar.
And
My problem.
We are, okay, sorry.
When the when it- whatever affecting
Not
no. Yes, my so I'm the court passing on item 842 in application of some I am deciding them. They are not- that Tahsildar, Patwari, subordinate officer, one could see both the survey numbers, 34/1/14, 34/1/15, contiguous to each other. And my lord, I can show my sale deeds, the record entry showing that I am there, and I will show photographs, my dwelling house is there, my lord. They can, so far as eviction order is concerned, they can implement. But so far as my possession over 34/1/15,
page 104 is the demarcation report.
104.
104.
This one. No, this report was considered while passing the first order by the Tahsildar. Not kindly appreciate. which was satisfied by the subdivision officer. It's 19 order, and my lord, the first order of the Tahsildar is 11th July 2023, which says that I have no jurisdiction. Page 98C came to be passed based on page 104. When the second time the impugned order was passed on 22/4/2025, a demarcation is required, my lord. The entire order of the first order of the Tahsil was set aside by the SDO. At page 100 and page 99. Lord, I'm not a squatter, Lord. It's not that on a fine day, without any lawful right, I have enforced the land of the private respondent. It's not like that. From my hard-earned money, by paying sale value, sale deed was executed, my right was conferred to me, my name is recorded. So far as 15 is concerned, I'm paying land revenue, obtain a sanction plan from the Portland Municipal Council to raise the building. The private respondent, lordship, before approaching the Tahsildar, he filed a suit seeking my eviction. Then he withdrew the suit.
So the SDO's order also directs your removal from.
Both the orders were challenged before the writ court. Both the orders, order of the SDO as well as the order of the Tahsildar dated 20, both were challenged before the writ court. Certain legal grounds. The writ court held simplicity and lordship that
In the same writ petition?
Yes.
The orders you.
Yes, I'll show this here. But kindly come to the writ petition at page 159. The part prayer portion in the writ petition, both the orders were challenged. Of the SDO as well as the Tahsildar dated 22/4/2025. Page 159. Prayer 2 and 3. A writ and or writ issue in the nature of mandamus, quashing and annulling and setting aside or resigning the cancelling the impugned office order number 22nd April 2025 by RC number passed and issued by Tahsildar. That's the impugned order filed by Tahsildar. 3 may kindly be seen. A writ and or issue in the nature of mandamus, quashing and or annulling and or setting aside and or resigning and or cancelling the impugned office order dated 30th May 2024 by file number so and so. Passed and issued by subdivision officer, District of Southern Oman. The order of the first appellate court setting aside the first order of the Tahsildar, the order of the Tahsildar dated both these were challenged, and writ court should have not considered these aspects of the matter. With due respect, I can say, because I'm deciding, not kindly see the photograph once. As I've been saying just now, Lordship, I'm not a squatter, simply sitter. I have no right to encroach also, Lord. There was some dispute, boundary dispute. My wife was elected. I've been put into possession over my land. I'm concerned with my land, 15, Lordship. But this material would indicate.
Unfortunately, 15 is not the subject matter
Yes.
of any of the proceedings, the Tahsildar or the SDO.
Or before the writ court. True. But a reasoning has to be established by the Tahsildar first. Only it records the High Court's order passed earlier.
Since you admit that you have no right, title, interest or possession in respect of 14,
Yes.
any other order passed in respect of 14 should not affect you.
Certainly not. I'm making a submission.
And all your contention is with regard to 14, not 15.
My point of argument is, Lordship. Lord, kindly make it clear, Lordship. Let them execute so far as 14 is concerned without disturbing my possession of 15. Because I'm in possession based on the possession certificate, based on the sale deeds.
There is no question of execution in respect of 15 because 15 is not the subject matter at all.
Lord, may I say one thing? Lord, I'm practicing here, not the ground reality as a lawyer, I mean. More particularly, the revenue department is one amongst such department which may go to up to any extent.
And not only that, 15 also, it is recorded that 15 you are not in possession.
But possession certificate issued by the Tahsildar is very clear, 2019.
Yes, but I believe the court has still dealt with 15.
Those
And
are
those orders are not challenged.
those orders, Lordship,
The
limited purpose, it can be considered for that proceeding. When
title suit, first appeal, second appeal, all but in respect of 15.
15.
So 15 is settled.
So 15.
And your name doesn't appear there.
No, my name is there. I have sailed it with. I can show the record.
Where is the title suit? Because the
I may be permitted, my lord, I will bring one by one.
Then
Let me finish,
let us hear.
my lord. Kindly come to my lord, page 47 first. In the operative portion, lordship will find at page 49. This is the initial proceeding, my lord, 19th April 2017.
For nearly 10 years, I am litigating, my lord, to get my property. Page 49, my lord. Got it, my
Yes.
lord? The first appeal, thereafter the second appeal, as well as the review application, all filed by Srimati Jayanti. Lordship, kindly take a note.
15.
Yes. Against the aforesaid order of Tahsildar. All were dismissed. So there is no legal bar to implement the order of Tahsildar. The Tahsildar is not taking any effective steps for implementation of his own order. As alleged, hence the Tahsildar Portware Tahsil respondent number 1 is hereby directed to implement this order dated 9th May 2014 passed so and so. This is the first order passed by this honorable single bench.
Yes.
This order challenged by the wife of the appellant, appearing at page 50.
Yes.
Number in the authority portion is page 52. We have gone through the order so passed by the honorable single judge. We do not find any illegality or infirmity in the order so passed by the honorable single judge. But the appellant has been deprived of his opportunity of hearing. We have to modify the order of the honorable single bench to the extent that the Tahsildar is directed to implement the order passed in RC number so and so within a period of 1 month from the date of certificate copy of the question order is furnished to him after giving opportunity of hearing to the consent. Thereafter, my lord, hearing was given, order was executed. Page 53. By the Tahsildar. Eviction order was passed against the appellant and his wife. Page 53. Thankfully, my lord, they are sitting over my property, filed the suit before the learned civil court. Now, my lord, thank you for the civil court's order. Page 57 starts from page 57. The operative portion, my lord, at page 70. Second paragraph, my lord. Finally, the certified copy of survey report dated 13/12/2019 by the surveyor Sri Jayanta Kundar, page number 40 of the exhibit A, clearly indicates that survey number 34/1/15 belongs to the plaintiff, namely Sri Saktivel, under occupation of Matthew Joseph. My lord, kindly take note. And the land bearing survey number 35/1/15 belongs to Srimati Sarla Baidia, was under occupation of the present plaintiff, namely Saktivel, by way of constructing the house. However, in the present case, the plaintiff Saktivel alleged that the defendant had pretended to evict him from the land bearing survey number 34/1/15. The allegation of the plaintiff in respect of the case is clear contradiction to the survey report and also contrary to the statement. Sri Saktivel in the revenue case against the Alex Matthew, page number 36 to 38. Rather, it is crystal clear that the plaintiff had encroached the land of the defendant, for which the erstwhile owner had also take legal course for removal of the illegal encroachment by the present plaintiff through his wife Jayanti. That is the first round, page 47. Accordingly, there is no reasonable ground to believe that the defendant, being the aged widow lady, has threatened the plaintiff to illegally evict the spot land. Considering all, my lord, the suit was dismissed. Now, may I kindly see the appeal court's order. It starts from page 78. District Judge's order. The operative portion, my lord, 86.
Yes.
Page 86, my lord. On perusal of the entire record. Got it, my lord? And hearing of submission of Leonard Blair both sides, it is very much clear. The survey number 34/1/15 belongs to the plaintiff, and survey number 34/1/14 belongs to the defendant. I further find that case is relating to survey number 34/1/15. I further find from the report Tahsildar that the survey number 34/1/15 is under occupation of one Joseph, Matthew Joseph. My lord, kindly take a note. Defendant also stated.
So these are all at positions now.
Yes, my property was encroached by him. His property is under the custody of some third party. He did not file any suit for eviction of Matthew Joseph. He filed a suit against me. Now, kindly see division bench order, my lord, page 93. He did not challenge this order. That is binding. Second appeal. Paragraph 2 may be seen, my lord. Both the trial court, appellate court on examination of documents, evidence have came to a definite finding that survey number 34/1/15 is under occupation of Matthew Joseph. And the said finding goes including affirmation of possession of Matthew Joseph is hereby proceeding between the parties. This is not binding upon him. Thereafter, Tahsildar passed this order. What is the wrong in the order, my lord? Lordship, kindly come to the order with Tahsildar.
Hundred one. 101.
Yes, madam, 101.
That's the order impugned.
Yes. But thereafter, Tahsildar passed 170. Kindly see 170. This order was never challenged. Kindly see the prayer made in the writ petition. This order was passed, the latest order, 1st May 2025. My lord, he is in illegal occupation of my property. This appeal should be dismissed with exemplary cause for the last 10 years. I am litigating to get property. I am a widow lady, senior citizen.
That's all your submission.
No prayer may be seen, my lord. This order was never challenged. Prayer in the writ petition. my lord. That was not never challenged. Yeah, you can file it by way of amendment. It was never done.
But it's part of your application.
Yes.
It's a consideration, but if the parent order goes, this is an order for implementation. If the parent order goes, which are challenged.
Concurrent finding of this amendment is already there. That when judgment is there. Is binding upon it. We cannot challenge thereafter. Cannot that we are hearing was given.
That's all your submission.
That's all, my lord. It should be dismissed
You
with
have-
explanation.
The page 93, my lord, the second appeal judgment passed by the honorable division bench, my lord. In that also, it was clear that survey
not
number.
admitted.
Yes,
Appeal was not admitted.
no,
Not finding is also there.
finding is also there, my
Yes,
lord.
yes.
That 34/1/15, which is the subject land, my lord, it is under occupation of Matthew Joseph.
My lord, may I submit one thing? I am praying for dismissal of this appeal, my lord, with the direction upon the Tahsildar to execute the order. Otherwise, I would get the property for another 10 years.
Stay application as well as the appeal.
Yes, my lord.
Right?
Both can.
Yes, yes. Arguments concluded. Judgment reserved.
One thing, my lord, he has taken the point that opportunity was not given to them during the proceeding, my lord. In RC proceeding, I have the records with me along with my notes and argument, short notes and argument, that they have appeared, my lord, through their counsel. The entire RC proceeding, they appeared, my lord. They have taken part on the RC proceeding, and it was within their knowledge that RC proceeding was going on and the order was passed in their presence. So,
Acknowledgement.
Next.
my lord, I would be appearing on behalf of respondent number 1 and 2, my lord.
Lord, my daughter was found dead in a mysterious circumstances. Was found hanging in the storeroom of my mother-in-law. But UD FIR was initiated. Instead of examining the body of this daughter by the executive magistrate in the police agency, her body was shifted to hospital. Even at hospital, the injuries were detected. And later on, her body was subject to postmortem examination.
No inquest held.
Inquest, not in terms of law, it has been held. Because the injuries, her body and the injuries as depicted by the doctor, pathologist, one would see. Pathologist examined her body, more particularly the neck part, because it's a case of hanging. The doctor have clearly opined of the effect of the, ultimately the police agency submitted a closure report to the sub-division officer that the administrative inquiry was done. The case was proposed to be closed. These aspects were challenged before the writ court and the writ was dismissed. But this court, this honorable court, in an identical manner, directed a CBI inquiry by Her Ladyship Honorable Justice Indira Banerjee, Her Lordship Honorable Justice as my Lord was S.K. Chakraborty. There the case was, girl was found hanging in a masjid. The court held the nature and the manner in which the inquiry was done was not proper and the matter was referred to CBI inquiry.
No complaint was lodged
I think
by the father.
not complaint was not lodged. My statement, the other side says that it has been recorded. In my statement, I clearly depicted, but they take some other statement because I have said that it is not a case of suicidal. Because Lordship several, the inquiries ought to have been done in the way it was not done. And writ court Lordship simply dismissed my writ petition, Lord, which against which the
There a prayer for a CBI from your part?
But I prayed in the writ petition for the independent agency. I've said so in my writ petition. I prayed in the writ petition. I can give the copy of the writ petition. My Lord would see prayer too. The writ annual writ division the nation of Mandana commanding respondent, that is station house officer, police station, Arno, to register FIR on the death of daughter of writ petitioner Africa and to hand over the entire case to independent agency for smooth and fair investigation. These facts need to be unearthed, but not in the way it has been done. It has been directed. Body was shifted from that place to the hospital. There is no inquiry made. And the executive magistrate, for the first time, says that there is no injury, more particularly the neck part. But in the postmortem, the report is otherwise. And
Did you file an Narazi against the final report?
No, Narazi was before the SGM. It's an had it been before the magistrate.
So it's an administrative.
Yes.
It's administrative.
It's under the it's an administrative inquiry. Had it been under the judicial mercy, I have the right to file my protest petition. So this whole thing have challenged in the writ petition, not the whole thing. My mother-in-law, with her, she was staying a day preceding to the date when the death occurred. She left morning. This is what the police said in the statement. She called the police. This is what the mother-in-law said. And finally, the police agency says there is no case.
In the case that you've referred to, there are certain circumstances. Have you seen this? No. The court has decided on a inquiry. Will the administration seek to use an affidavit? Because the entire investigation has to be looked into. The relevant documents,
Yes.
the considerations of the authority.
We'll find it, my lord, then.
May I say one thing? Before the writ court, it can be sent back to the writ court. Because
an appeal.
They have, so it's not clear, not if this matter is sent back to the writ. The entire issue needs to be considered as fresh.
For sending back also, yes, my brother is right. We have to prima facie hold that the order is for us.
I can satisfy
We
this.
cannot,
I can personally.
unless the documents are before this court, we cannot hold that. We need to see the process of investigation.
Thanks, my lord.
And there is no legal bound affidavit in a second week, is there?
Normally, but it's the memo, it's not a form of a prayer, so that my understanding is not can direct.
In this appeal also, there is affidavits filed by the parties.
But that was and based on such.
This was a public interest litigation.
Public.
The writ court used to appear for the police. I'm not aware. When I heard the argument, then I see.
I'm giving a clear copy.
I think we request. Yes, we need to see the documents. I mean, whether the nomenclature is an affidavit or a report or whatever, we need to see what has happened exactly.
And
Lordship, every aspect has been decided.
Serious issue.
No, Lordship,
So-
kindly appreciate Lordship. 1 minute, Lordship. Circumstances was totally different. After 1 year, the father came to this court without making any complaint. During it, was recorded. He has no suspicion that here something was happened, it was not a suicide, no complaint at all. No, after 1 year filed. During the investigation, during the inquiries, he recorded. He clearly stated what is happened on that.
He did not raise any objection.
Any
Any application regarding suicidal.
after 1 year, they came to this red court, saying that it was not unnatural death.
Will you please come back with the report indicating the details of the investigation?
That was already before the
He's
red
in
court.
opposition
That was within the red court.
police department.
There is nothing is annexed to the second appeal. These documents should not be here.
I could have filed this, there an application I can file because simplicity memo has been filed. So I cannot even annex it in the appeal.
No, you cannot.
That's the point.
So will you come back Thursday and say, I mean, all the relevant.
I have gone through the
documents-
judgment, my lord. The circumstances are entirely different.
I-
The
See,
learned
fine.
friend has,
Yes,
to
that's
post
what the
judgment.
prima facie file.
yes, my lord.
So we would like to see the entire court of investigation. If that is already before the writ court, I'll request.
Filing a special supplementary affidavit.
Yes,
If you
that
have
you
supplementary
can.
affidavit, I can bring the opposition media.
Please annex all the relevant documents.
We are
What
filed.
there before the writ court when this was decided.
Yes.
I mean, the single bench has dealt with the.
Yes, my lord,
May
all
I
the
say
documents.
just, this is the opposition file. You would see the same document which are annexed post-mortem is the only document they have filed. What can look into this?
The statement of witnesses are
Same-
witnesses.
same-
No, statement of witnesses are
Yes, yes, everything has been annexed.
there. Statement of witnesses are there.
They have annexed it.
Postmortem. Where are the statement of witnesses?
This is the opposition which they are before the writ court, not against my writ petition. And this document I have filed in my writ petition.
File report.
These are my documents.
See the statement of
Lordship,
witnesses.
Lordship.
Everything is
It's
there.
part of the writ petition.
We'll state to come,
Well, I'm ready.
which will also contain these documents,
Well,
right?
Lordship.
The appellant. As I said, the order of the learned single bench dated June 13, 2020, in the 21 of 2025. Learned counsel for the appellant submits that the appellant's daughter expired under unnatural circumstances. A final was submitted by the investigating officer without holding proper investigation. The statements of witnesses, including that of the appellant, were not considered in their proper perspective. by the investigating officer. Your prayer was for further investigation.
My papers to after the party was committed by the police
The
agency and for holding
appellant
investigation by the independent agency.
has sought quashing of the final report and a fresh investigation by independent agency, comma, for example, the CBI. Paragraph will counsel for the respondents seeks to submit a report annexing relevant documents pertaining to the investigation. When- Next week,
Next people.
Monday,
Wednesday or Thursday?
or can it be taken up? That's at the end of Thursday. We'll come back on Wednesday. Let's try.
Lots.
Let the matter appear under the same head. Please give an advance copy.
Lots.
Please annex these documents also. Next. What can whose order?
Justice Arjit Banerjee and Gautam Majumdar.
So this court cannot deal with it.
Register may be directed to raise the matter before the council.
The order under contempt. Where is the order?
Page 25. Contempt order over. Contempt order.
23. Contempt dated August 2, 2024 has been passed by an honorable coordinate bench of this court. Paragraph in view of the above, comma, the matter be released from this court and placed with honorable justice, comma, High Court, Calcutta for necessary direction. Next.
So I for the respondent state lordship.
Order dated 2/7/2025 may be seen. He has specifically prayed for this honorable court that the file has been given back to the client and he withdraws his power. And the member secretary was thereafter directed to engage another advocate.
Your Miss K. Bhavan?
Yes,
Your name is being recorded all throughout.
yes, sir, that was yesterday when I asked this honorable court, I will take exception from it.
If the appellant is not there, then what will the member secretary do? The appellant has not approached the court any further.
So but can and the SLSA was directed to. Because without defending anybody for that reason, court has so much.
The appellant needs to come before the court and say that she wants to continue and needs to be represented.
Thereafter that.
Thereafter, this is done. So this has been sworn to done.
Not so.
Let us call for a report from the member secretary. It's an order being- The appellant is not represented. VD order dated 2nd July 2025. Comma. A coordinate bench of this court directed the member secretary of Andaman and Nicobar State Legal Services Authority to engage an advocate from the panel of ANSLSA, the appellant, present matter. Paragraph, a report be called from the member secretary in this regard on the adjourned date. Paragraph, let the matter appear, and let the matter appear under the same heading on 1st August. Or let it be on 2nd August. 2nd August, it's a working Saturday.
Lordship, Friday or Monday, Lordship.
Yes,
I come with you. Friday or Monday?
1st August.
Oblige, Lordship.
No, matters absolutely in the list on. This is a working Saturday.
Lordship. Yesterday we. No.
Next.
The appellant states against the acquittal under prevention of corruption. Bribe case, you are the acquitted, I have challenged that.
Paper is ready.
Yes, Lordship, paper is ready, leave granted, section 5 allowed. Appeal is ready for hearing.
You want to come back to court? On prayer of the respondent, matter is acted for today.
N11 are appeals against acquittal. I'm for the victim, I don't defend for the state. We are also paying for not today.
All the appeals are getting accumulated.
Another matter is.
Saturday.
Tomorrow.
Saturday. 2nd, we'll have lots of time, we'll hear of that. Everyone cannot have a difficulty answer. It's a working day, we need to keep some files.
I'm aware it is a working day, but your lordship is also aware I'm a member of the Calcutta Bar Association.
So it's a working day for Calcutta also.
It's a working day, but I have.
So this is all the more reason for you to be present.
I am the one person in the Calcutta High Court who has appeared and argued 17 appeals on a Saturday before Justice Bagchi at that time.
So why don't we add another to that?
I'm equally aware of what I faced before the bar because of that. And I'm fully aware that there have been repeated Saturdays declared as working days, and the bar takes a certain stand, and then we get an embarrassment. That's why I'm saying.
It was so difficult.
We will not pass any adverse order, we'll shift it to Monday. Let it appear on Saturday. We need to keep some matters on Saturday, right?
Understand, my lord, kindly understand my position.
I understand if you are not ready, we'll shift it to Monday, let it appear on.
I have
Yes.
difficulty appearing, but unfortunately, our
That's-
Calcutta, there's a certain stand taken because this has been going on for many years now. But
Yes.
that is the one day we get with clients, drafting, sitting in chamber. That is one day when,
No, but it was open with the,
Lord, I can tell you, Lordship, at least 4 or 5 occasions where this has been done. Saturday has been fixed as a working day. And then last minute on Friday at 8 o'clock, the bar will take a resolution. Then if we come, we face difficulty with the bar. If we don't come, we face difficulty with the bench.
No, with the bench, you'll not
So-
face any difficulty.
No, madam, just.
Let it appear, we'll shift it. Don't worry.
No.
You are the private respondent.
Responded.
Learned counsel for the respondent seeks accommodation. Let the matter appear under the same heading on 2nd August. Let these matters appear. One is by the state, one is by the victim.
One
These
is
are the
by
two
me,
things.
one is by.
By the state.
Just briefly, the 376, 13.
Oh, it's that matter.
Oblige.
Yes,
I am for the appellate matter. I have gone through the opposition judgment.
I need some time to file. Allegations were leveled against. I need to file reply to this opposition.
Next week.
Reply next.
Yes. Who is appearing for the respondent?
Mr. Khan is for that. You can, Tuesday.
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 Learned counsel for the appellant seeks accommodation to use a reply to the affidavit in opposition. Paragraph, let the matter appear. Will you come on Saturday? Second. There will be less pressure, so we can deal with Saturday. And let the matter appear under the same heading on second.
Interim order was not extended. I have not asked for it.
Oh, you've not asked for it? Oh. When is the interim order expiring?
My lord, 4 weeks time was given,
From?
from
Is it covering 25th August, the next Saturday? No. Let this appeal list.
item
Tomorrow.
number 67 from yesterday. For newspaper. 57.
Let it appear in the list.
Madam, that would be 106 of 2021.
Or Blair. My lord, I want to mention 4 matters, my lord. They are from long, they are not coming in the list, my lord. Last.
What are they? What are the matters about WPA?
Yes, my lord. Okay.
Let them include it. No. Under WPA. No. New motions.
No.
Well, hearing a motion, what is it? So let me come at a motion. And please, it's very cold, please.
Lord, I'm for the petitioner.
For the respondent, state lordship.
Lord, two sort of accused under the same charge sheet. Under the NDPS Act, my lord, NDPS Act, my lord. So I have filed both the accused bail application. One has been released from that court, but I know, my lord, it is not listed
Yes,
today.
so this
I made a submission,
Yes.
but it is not listed today's list before lordships.
Has it been released?
Yeah, released, my lord. Yesterday I made a submission to that court. It has
That's
been
what the
released.
other parties found.
But lordship court number 2 has already released yesterday that matter.
It's several.
Six, 7.
Released by court number 2
Yes,
yesterday.
my lord.
Oh, you need to mention again. Then we get it up in this.
I'm sorry, my lord. Then I'm extremely
Let it
sorry.
appear tomorrow. Both these matters together.
I suppose sitting
You are appearing in this,
For the states.
by consent of the parties. Let the matter appear under the same heading on 30th July. And
CRM.
please include the other matter also.
And
together.
I'm giving the number. My lord. This is CRM NDPS 7 of 2020. 7 of.
Next.
My lord, in this matter, I am appearing for the writ petitioner, my lord. Same thing, my lordship, in court number 2, one matter was fixed. We had made a submission and the matter was released from court number 2, my lord.
I
And
believe
it was,
mentioned so that the matters appear in this list.
Yes,
Yes.
that is to be mentioned here.
well, then I may be allowed to.
Please include it.
Yes.
Item number, please give the number.
Yes, ma'am. 336.
Consent of the parties, let the matter appear on the same heading on 30th July. Fix it tomorrow.
Yes,
Let the other, one matter.
only one matter.
3 analogous matters, my lord. 2 is listed before these lordships and 1 is listed.
Yes, the one, only one is.
Please take the number and list it tomorrow.
Similar matter. 2 and 3.
2 and 3
Two and
and
three are
other one,
yes.
same one.
You know, just not today, your worship. Item number 4 just comes.
Yesterday also it was appearing, right?
Your worship, first time.
Oh.
Paper,
Anyone for the respondents?
VAT, DC, Joint Commissioner. Service.
On, you are appearing in.
Not for that, deputy commissioner used to appear. If you can give copy that.
I will give a copy.
On
So that we can come ready.
The matter is attended for the day.
Yes.
I don't think this matter, appearing this matter, not today. Some other petitioner.
Not today. On prayer of the petitioner, the matter is adjourned for the day.
I pay for the respondent.
In this matter, I am for the petitioner. I am filing the petition for a new electric connection of the encroachment land matter. Madam, already the matter matter.
An opposition was called for.
Yes, madam.
Who is appearing?
I am for the petitioner matter.
Mr. Mishra. Who is appearing for the respondents?
Mishra, they can. Mishra, my lord, Mishra.
Not part of my junior.
The opposition was supposed to be filed. I do not. You are appealing?
I am appearing in item number 6, Lordship, for the respondent.
Yes. For the electricity department.
Lordship.
You have to file your, you wanted to file an affidavit in opposition?
Lordship, let it be fixed in the next week. In the meantime, I will file my.
Learned counsel for the respondents seeks extension of time to use the affidavit in opposition as sought. 1 week?
Lordship.
Affidavit in opposition be filed within 1 week from date. Affidavit in reply, comma, if any comma be filed within a week thereafter. The matter be placed before the next available supplement.
Item 7.
My lord, I am appearing for the petitioner.
Lordship, here whether they have served the department or not, I do not know.
Service is not completed, my lord.
It's not complete.
Day after tomorrow, I will come.
Saturday, 2nd.
August.
Since service upon the respondents is not complete, comma. Then
I filed the advance copy to the respondent.
Lordship, let them serve the department, they will provide me. Why she will waste her money?
No, if you require an advance copy to be prepared, you can take that.
Okay.
Let the department serve
Lordship.
on 2nd. Next.
August.
My lord, I appear for the writ petitioner, my lord. The 8.
Lordship, just today morning I have received the brief. Let it be tomorrow, Lordship. I will make appropriate submission.
The service has not been effected on the respondent number 3 and 4, Your Honor. My lord.
You need to serve and come.
Ha.
2nd August.
No, let the matter be fixed on next Monday.
2nd August.
Second.
Since
Problem.
service upon respondent numbers 3 and 4 is not complete, comma. Let the matter stand over till 2nd August.
Obliged, Lord.
Next.
Sarath. R. Sarath.
Item 9, here 1 of 25.
I'm appearing. No, still the same, not because there is a complete complainant himself appear.
Nine.
He is directed to submit a report.
No, Usmani, 9, Blair.
I'm sorry, madam. I'm sorry.
9. Next up. First, I am for the appeal and state lordship. It is appeal for enhancement of the conviction. 3 years punishment was given. Kindly go through the last order, lordship.
What is the application? What about the accused? Have you served?
And not served for SLSA was directed to. नहीं, SLSA.
The accused respondent was represented on the earlier date.
Yes, thereafter this
Paper
court.
books ready?
Paper books ready.
Oh, it's here, yes.
एक बार पेपर फिर SLSA direction. कौन हुआ था?
Nobody appeared for the accused, your lordship. Nobody appeared.
What is the CRAN about?
Plan is
First-
for compensation.
Oh, अब था ना?
But since he seeks enhancement, the accused needs to be served.
Lordship.
Yes.
Where is the direction on the SLS? I do not find.
There was a specific order for that.
Order dated 18th February 2025.
Yes, there was a direction upon the member secretary SLSA to see that the respondent number 1 is to be represented.
Yes.
Is anyone there for the SLSA? Yes? Please come. What is the name of the accused?
Ganesh P.
I filed a Vakalatnama for this.
It is after that 18 March order or before that?
June, 17 June 2025.
Yes, it's.
That means he is
Is
represented.
represented.
Who is the counsel here?
Siddharth.
Siddharth.
Will you inform him? Let me.
I
fix
will
it to
inform.
all.
him.
I'll just make.
Lord.
The accused slash respondent is not represented. The matter is adjourned for the day. He is on the earlier date, he was there, so let them inform.
If I am for the respondent, Lordship, there was a last direction upon the state to file a report. Lordship, this case related to police station Campbellway. Today, SHO concern had just reached due to the bad weather. After passing, so tomorrow or day after tomorrow, I will file a report. After serving the copy to the other. Matter related to one suspected person.
You are the petitioner.
Lord, yes, I've been represented through SLSA that complaint himself has appeared, but this court has passed an order to assist the complaint.
156 filed for.
But the fact is that he has been tortured in the police custody, so he made an FIR under 156. He approached to the CGM, but CGM court has not registered. Then no order has been passed. Against he went to the district and sessions court. Against that order, he prepared a civil criminal revision before your lordships. So this court, after going into the complaint, directed the concerned SHO to file a report with regard to the fact and
incident.
This is the accused petitioner.
Accused petitioner.
What about the private?
What happened, Lordship? May I?
Arrested under Foreigners Act.
Lordship,
He have been
may I?
kept under the custody and he has been tortured. So that's he saying that when I have been tortured unnecessarily, I am making a complaint against the police authorities who have been tortured. So the complaint has not been registered by the SHO. Then SP has not been registered. That is, he has come to the proper channel. But now the report has to be there. Whether the allegation raised by him, none of the courts have seen in with regard to that report.
So you are representing all of them, right? 1 to 4.
One is state police department laws.
Yes, state and police department. Yes. Yes. You'll come back day after with the
Day after, Lordship, I will file a report. SHO already reached from Gamble Bay.
Learned Counsel for the state seeks accommodation to submit the report in the form of affidavit as called for. Paragraph, let the matter appear under the same heading on day after this 31st. First.
I'm for the appellant, Your Lordship. Your Lordship, first, Your Lordship, I'll take Your Lordship to the substantial question of law which has been framed by them. Kindly come to Your Lordship, page number 162 of the paper.
Yes.
Whether the learned first appellate court substantially erred in law in arriving at the perverse finding that it is evident from the claim that the limitation for filing the suit started from the year 2000, whereas in the relevant paragraph of the claim, the plaintiff did not make any such error. Whether the learned appellate court was substantially erred in law erroneously interpreting the applicability of second limb of Article 54 of the Schedule of the Limitation Act 1963 in the context of the present case. Your Lordship, as suit for specific performance was dismissed mainly on the ground that it is barred by limitation. That is the main thing. Now, Your Lordship, while relying upon that particular, while taking a decision to that aspect, the learned first appellate court relied upon certain paragraphs of my claim. Now, Your Lordship, I'll take Your Lordship to the To the judgment of the first appellate court. At page
121.
page number 121. 125.
No, 121.
The judgment is at 126. Oh, decree, no?
Start with the 1.
126, yes. It's a lengthy judgment, Your Lordship, but I have to place it. The reason is that this is a second appeal, Your Lordship knows. Every part of that we have to see. Your Lordship, it starts from, I'll just take it, Your Lordship, from page number 129. Decisions with reasons. Rest, Your Lordship, the arguments of the parties have been recorded. Yes. The instant appeal challenges the impugned judgment dated 29/10/2021 and decree dated 10/11/2021 passed by Learned Civil Justice Junior Division 1, Portland, South Andaman, whereby the suit filed by the respondent plaintiff Preetham Singh was declared on contest against the appellant's witness and the decree for specific performance of contract for sale of suit scheduled property, that is land hearing survey number 502 measuring 200 square meters situated at Sippighat Village, Portland, Tehsil, South Andaman district against the appellant defendants, and they were directed to execute a registered sale in respect of the suit and within a period of 3 months from the date of the judgment. In default, the respondent plaintiff was given liberty to put the decree into execution as per law. The respondent plaintiff was further granted a decree of permanent injunction, thereby the appellant's defendants were restrained permanently from interfering in the suit and to anyone else other than the respondent plaintiff. It appears that the respondent plaintiff filed one suit on 14/7/2016 for specific performance of sale agreement dated 24/12/1998 in respect to land hearing survey number 502 200 square meter situated at Sippighat Village, Portland, Tehsil, South Andaman, valuing the same at rupees 15,000 on the allegation that appellant defendants are heirs of late Rajaram, who expired on 19/3/2003, and he was recorded tenant of the above suit scheduled land. The further case projected by the respondent plaintiff before Learned Trial Court is that he and Rajaram were known to each other and they were classmates, and when Rajaram intended to sell the suit land to meet his financial need, he approached the respondent plaintiff and he agreed to purchase the land. And to this effect, one sale agreement was entered on 24/12/1998 for the sale consideration of rupees 15,000, out of which the respondent paid rupees 10,000 as advance, and the balance of 5,000 was agreed to be paid at the time of registration by the said Rajaram. The further case of the respondent plaintiff in the plaintiff is that in pursuance to the sale agreement, physical possession of the suit was given to the respondent plaintiff, and this agreement was witnessed by the witnesses, namely Premlal and Narayanlal. Premlal had already expired. It is further contended that plaintiff Rajaram was working as a peon in the deputy commissioner's office, and whenever the respondent plaintiff approached him to get the sale deed registered, he avoided. And now, Your Lordship, this is important. To get the sale deed registered, he avoided. And sometime in 2000, the plaintiff told, the Rajaram told the plaintiff that in order to get the sale deed registered in respect of the suit land, permission is mandatory, and the plaintiff believed it was. And on this, Rajaram expired. And after his death, the plaintiff approached his legal requesting him to register the sale deed, but they did not take any step by saying that unless the land is mutated in their name in favor, the same cannot be registered, and there was no disturbance to the possession of the respondent plaintiff. Now, Your Lordship, the recording, so far as the recording is done, it is the word avoided has not been used in my claim and neither in my argument. However, it has been stated here. Now, Your Lordship, the further case of respondent plaintiff is that in first week of July 2016, the appellant defendant started troubling the respondent plaintiff by asking him to vacate the suit land and refused to leave the sale deed in his favor, and they are trying to demolish the fencing of the suit land. On this ground, the respondent plaintiff filed the suit before the Learned Trial Court on the ground that he is ready and willing to perform his part of contract by paying rupees 5,000. Upon notice of the suit issued upon the appellant written statement was 5J. The material allegations were denied, and it was contended that suit is barred by limitation not granted. The amendments of the plaintiff as to execution of any agreement for sale was specifically denied, and it was contended that the respondent plaintiff obtained signature of deceased land papers, which was later on the date of death of late Rajaram as 19/3/2003 was admitted, and it was specifically said that its suit and land is in active possession of the defendants, and they applied for demarcation before Tehsildar, whereupon notice dated this and this were issued to plot holders, and on this verification was done. The lodging of NCFIR by the respondent plaintiff was alleged to be an afterthought by the appellant, and prayer for dismissal of the suit was made. It appears that the Learned Trial Court finally considered the following issues. whether suit is maintainable in its present form in law, whether suit barred by the law of limitation, whether an agreement for sale in respect of suit was executed by Rajaram since deceased, being the husband of defendant number 1 and fathers of other 2 defendants on 24/12/1998 in favor of the plaintiff, whether any such agreement for sale is valid in the eyes of law and binding upon the parties, whether the plaintiff is entitled to the decree at phase 4, to what other reliefs the plaintiff is entitled. It appears that when a trial court claimed 2 additional issues which are as under whether the suit filed by the plaintiff is barred under the law of limitation, whether service of notice demanding the execution of the sale is mandatory or not for the suit for specific performance of contract. If the answer is affirmative, whether the plaintiff sent any notice representing the defendants for execution of sale at any point of time. It appears that during the course of evidence, before the trial court, 3 witnesses, namely Pritham Singh, V. Loganathan, and Narayan Lal, were examined as PW 1, 2, and 3. While appellants examined 2 witnesses, namely Sandhya Rani and V. Loganathan, DW 1 and DW 2. The documentary evidence on behalf of the respondent taken from Exhibit 1 and to Exhibit 5, that is sale agreement, look at this signature of PW1, signature of Narayan and Rajaram on sale agreement, NCFIR number is dated this, authorization letter of Portland Tehsildar, ROR of the suit and sketching. While on the other hand, from the side of the appellant defendant's document, Exhibit A to C, the authorization letter, compliance report, revenue order sheet, notice, and record of right. The impugned judgment further shows that the trial court took up the issues 1 and 2 together, wherein the issue as to the maintainability was decided by holding and suit is not barred in law for the time being imposed, and the respondent plaintiff has sufficient cause of action to file suit. The issue of limitation was taken up along with issue number 3 to 6 and additional issue number 1 and 2. When the lower trial court relied upon the agreement for sale details and referred to section 68 of the agreement as well as the evidence of PW3 and the written statement of alleged defendant wherein the contended and received Rajaram and approached the plaintiff responded for loan of rupees 10,000 and he managed to get his signatures on blank bond paper, which was subsequently converted into agreement for sale. And the lower trial court held that the execution of agreement database was admitted by the defendants, and lower trial court referred to section 17(1)(a) of the Registration Act 1908 and section 53(a) of the Transfer of Property Act, and as on 24/12/1998, the registration of the agreement for sale was not mandatory. In order to attract 53(a) of the Transfer of Property Act, the trial court further observed that as per Article 54 of the Schedule to the Limitation Act 1963, the period of limitation for filing a suit for specific performance 3 years. Then a trial court further referred to the pleading that Rajaram expired on 19/3/2003, and after his death, he approached legal heirs of Rajaram in December 2003 for registration of city, but they told them the land will be in their name after mutation. However, they did not take any step for mutation, and in the first week of July 2016, the appellant defendant started troubling the respondent plaintiff and we lodged NCFIR in this regard. Lower trial could further observe that the DW1 Sandhya Rani admitted lodging of NCFIR and admitted that they applied for demarcation of the suit and with President and mutation was done in their name in the year 2015. We did revenue case number this, as such, the appellant defendants failed to negate the claim of the respondent plaintiff. The learned advocate for the appellant defendants seriously argued that PW1 frequency admitted that the sale agreement was not registered, and full name and the address of the witnesses have not been mentioned therein, as well as after the execution of the agreement to the death of Rajaram, the respondent plaintiff did not send any legal notice to him requesting him to execute the sale deed. The writer has been used in para agreement to erase some words, and possession of the suit line was not handed over on the day of agreement. He did not submit any document to show that he is in possession of the suit line, and he did not issue any legal notice that he had, and even did not move any application before Tehsildar after death of Rajaram, requesting not to do mutation in favor of his legal heir, and also admitted that the suit land stands in the name of all the 3 appellants, as well as his land situated beside the suit land. Another advocate further referred to the cross-examination of PW2, PW3, as well as DW1, Sandhya Rani, and DW2, B. Loganathan. He further challenged the judgment and decree on the ground that the trial could go with the admission of PW1 with the use of bilateral agreement, para number 3, and the position of PW2 that no notice was issued to Pritham Singh for demarcation of the suit land, as well as the alleged agreement of sale was executed on 24/12/1998, while the suit was filed on 14/7/2016, which is hopelessly barred by limitation, which is 3 years from the date when the performance of the agreement is reduced, as well as the limitation for such agreement had started to run 24/12/1998. He referred to section 16B and C of the Specific Relief Act. He also referred to the provision of section 20 of the Specific Relief Act that learned trial court failed to consider that the court is not bound to grant specific relief in a case where the suit was after 18 years And during these period, value of the suit land had escalated, due to which a hardship would be caused to the appellant defendants, while no such hardship would be caused to the respondent plaintiff in case the compensation is granted in section 21 of the Specific Relief Act. He relied upon the Solomon decision in, I'm just skipping this, citation for setting aside. Now, on the other hand, advocate for the respondent plaintiff contended that there is no stipulation in the sale agreement with regard to any time limit, and as such, the second limb of Article 54 of Limitation Act shall be applicable. With regard to corrections, the use of Whiteman and sale agreement argued the sale agreement is a documentary agreement and no plea has been taken that anything has been erased by the Whiteman by the plaintiff. It has also been argued that no law requires the agreement to be notarized. PW1 admitted that she is residing at a far distance from the suit land, and the trial could specifically deal with the issue of limitation. Advocate further referred to the evidence of PW2 that the position was handed over to the responsibility after 3 months of the sale agreement. No time limit is prescribed in this agreement. The necessity for sending the notice arises only when the same is mandatory as per specific relief act. There was no requirement for filing objection to the limitation. Ryan specifically deposed that position was handed over to the respondent plaintiff after 3 months from the date of sale agreement, and PW2 could not say about construction over the suit land. It is further argued that agreement dated this, wherein advocate for the respondent plaintiff relied upon the decision in fact number 26. Upon scrutiny of the evidence said by the parties before the trial court, it appears that PW1 in examination in chief reports of the same line as that of the element of his claim, and his cross examination revealed that he did not send any legal notice to Rajaram during his lifetime for execution of sale in his favor, and the vital portion does not bear any signature of Rajaram or signature. He did not send any legal notice to Rajaram after obtaining possession, asking him to execute proper sale deed in his favor in respect of suit property, and he did not file any document to show that he is in possession of suit land. He was acquainted with the news of death of Rajaram. The distance between his house of that and that of Rajaram is about 200 meters, but after that of Rajaram, he did not issue any legal notice to his legal asking them to execute the sale deed, and his class 12 pass and a government employee. He never made an application for the rest after that Rajaram represented not to do notation in favor of his legal death. This is the finding election. From 4.2 finding start. PW2 V. Loganathan, election just pausing for a moment. No substantial question of law has been framed. But if your lordship feels that any other substantial question of law is required to be framed, your lordship is free to raise. But it should be known, your lordship, because I suffered, your lordship, in one of the cases where the substantial question of law has not been framed and the decision has been taken, your lordship, on that particular point. So I will be coming to know that what is playing in the mind of this honorable court, so that I can answer properly. Now, PW2 V. Loganathan is the figure who proved the certified copy of record of right and statement in respect to the suit land in the name of Rajaram, and thereafter it was petitioned in the joint name of Sandhyarani, Sudeep Ram, Kavitaram. He further admitted in the cross-examination that anyone objected for transfer of the petition, the name of the person is registered with the dispute register, but he has no idea as to whether names of legal heirs of Rajaram have been mentioned in the dispute register. Evidence of PW3 shows that he deposed that he was the witness to the agreement in between Rajaram and Pritam Singh along with Plainland. His deposition revealed that he identified the signatures on the agreement and is not mentioned in the agreement that the position was handed over after 3 months and he did not know whether any notice has been served upon Rajaram by Pritam Singh between 1998 to 2003 or after his death to his legal heirs, and if publication in the newspaper was made. PW1 Sandhyarani proposed a chief affidavit on the same line as that of this written statement. She deposed in cross-examination that she does not have any knowledge regarding sale agreement with this, and mutation of the property was done in the year 2015. PW2 V. Loganathan produced the compliance report and order sheet with Nasi case number 6 and also produced a record of rights inspection. The documents relied upon by the parties is one alleged agreement which has been proved by Exhibit 1, whereupon signature of 20 respondent has been marked as Exhibit 1 by 1, that of Narayan as Exhibit 1 by 3, and Rajaram as Exhibit 1 by 3. As per the terms of agreement, rupees 10,000 stated to have been received out of 15,000 by Rajaram, with an undertaking to deliver the possession within 3 months. Exhibit 2 is a daily telegram newspaper, while Exhibit 3 is NPFI records, according to which allegations have been released by Pritam Singh, the respondent of the plaintiff, that he occupied this property on the strength of agreement for sale, and legal aid of Rajaram tried to demolish fencing of the land in question. The Exhibit 4 is the attested copy of the record of rights. Exhibit 5 is site plan sketch plan. The documents Exhibit A and B are the authorization and notice, along with the compliance report, according to which, as per the demarcation, the boundaries of the land was shown to belonging to Sandhyarani Further, the demarcation is was sought by Sandarani, while the letter with Exhibit 5, collecting and adjacent boundaries of Sandarani bases that which shown as Francis Window and PR Period. Thereafter, as per Exhibit C, name of Sandarani Sudhika and Kalpana must be followed in the record of demarcation and verification. In considering the arguments advanced by the learned advocate for the appellants and the solemn decisions relied upon, it appears that the main thrust of arguments of learned advocates for the appellants in the written argument is that the agreement in question was not registered and the cross-examination of the plaintiff PW1 has been referred, wherein he admitted that after execution of the agreement before demise the Rajaram, he did not send any legal notice to him requesting him to execute a registered sale deed in his favor, and in the agreement, Whitesell has been used, but there is no signature of Rajaram and the place where Whitesell has been used. It has been admitted. It has also been admitted that no document has been submitted by PW1 that the possession of the suit land was handed over to him. After death of Rajaram, he did not send any legal notice to his legal heirs asking them to execute the proper sale deed in his favor, and he did not make any application before Tehsildar after death of Rajaram requesting not to do mutation of the property in favor of his legal heir, and presently the suit land stands recorded in all of the three defendants. The cross-examination of PW2B Logdatin also revealed that after proceeding is mandatory to change the name of recorded tenant is handover, and if anyone objected to such transfer, name of the said person was to be registered in dispute register. The main argument of the learned advocate for the appellant is that the suit is barred by limitation and the issue of limitation has not been decided by the learned tribunal correctly. It also referred to the section 15B and C of the specific relief act. In 1987 Supreme Court 724, the Honorable Supreme Court discussed provisions of Section 20 of the Specific Relief Act 1963, which provide for judicial discretion reports as to declaring specific performance for which the court should meticulously all facts and circumstances of the case, and the court is not bound to grant specific merely because it's lawful to do so. The motive behind the application should also enter into the judicial verdict, and the court should take care to see that the decision is that the population to the unfair advantage to the failure. The argument of the decree of the trial court was confirmed only to the extent of half share in the property in the specific facts of the case. In 1999, the Supremes, as the before also, the Honorable Apex to discuss provisions of Section 20 of the Specific Relief Act and refer to the constitutional decision of the Honorable Supreme Court in Chandani versus Kamal Rani, reported in this, wherein the Honorable Supreme Court, after referring to various solemn decisions in paragraph with the head, that from an analysis of the above case, it is clear that in case of sale of remove away, there is no presumption as to time being essence of the contract. Even if it is not the essence of the contract, the court may infer that it is to be performed in a reasonable time if the conditions are evident. From the expects terms of the contract, from the nature of the property, from the surrounding circumstances, for example, the object of making the contract. The next reliance advocate for the appellant is upon the Solomon decision in 2001, Volume 5, SC, the Supreme 730, and the Honorable Supreme Court discussed the case law on Section 22 of the specific that granting specific performance in applicable relief, though the same is now governed by statutory provisions of specific relief, and while granting a degree for specific performance, the statutory guidelines under Section 20 of the Specific Relief Act should be kept in mind. The Solomon decision in 2002, Supreme Court 974 also pertain to the issue under Section 14 and 20 of the Specific Relief Act. In 2011, Supreme One, it has been held by the Honorable Supreme Court that time is the essence of the contract depends upon the terms of the contract. In case of sale of removed property, normal presumption is that against the time being the essence of the contract. However, even if the time is not, the essence of the contract has to be performed in a reasonable time. In this case, also, Honorable Supreme Court references Solomon decision Chandan. The Honorable Allahabad Court in 2013 Supreme Court, while discussing the Article 54 of the limitation and held that after expiry the period in the agreement for sale, the entitlement of plaintiff for payment of balance consideration received as result in cessation of his right to pay the same deed executed suit for specific performance is not maintainable. In Para 15, it has been observed that the suit for specific performance limitation and delay or unreasonable latches both have their own but independent relevance. If the suit is filed after the period of limitation, Section 3 of the Limitation Act 1963 clearly obliges the court to discuss it being barred by limitation. Question of discretion does not arise if the suit is otherwise within a period of limitation. Still, the court is not bound to take the suit by imposing specific performance of contract if it finds that there is an unreasonable delay or latches on part of the plaintiff. So the jurisdiction of the court to decree the suit for specific performance is discretionary through, though guided by certain legal principles stated in Specific Relief Act 1963. The application of limitation is mandatory, and by application of paragraph of relief is within the discretionary domain of the court. The Honorable Allahabad High Court in Para 16 of the judgment referred to the Solomon decision of the Honorable Supreme Court to explain the term date. The Honorable 3 Judge Bench in a decision held as under. Inevitably, conclusion is that expression date fixed for performance is a crystallized notion. This is clear from the fact that the second part, time from which period begins to run, refers to a case where no such date is fixed. To put it differently, when date is fixed, it means that there is a definite date fixed for doing a particular act. Even in the second part, the stress is on when the plaintiff has noticed that performance is refused. Here again, there is a definite point of time. The plaintiff notices a refusal. In that case, both the parts refer to definite dates. So there is no question of finding out an intention from other circumstances. Whether the date was fixed or not, the plaintiff had noticed that performance is refused and the date thereof are to be established and with reference to materials and evidence to be brought on record. The expression date used in Article 54 of the schedule to the Act definitely is suggestive of a specified date in the calendar. The answer the reference at 11. The matter shall now be fully noticed. In 2017, Volume 5 SEC 178, the Honorable Supreme Court, while discussing provision of Section 20 of the specific the principle for exercise of discretionary command. In 2023, the Honorable Deputy High Court, while discussing Section 20 of the specific relief act, observed that in cases where concerning immovable property, irrespective of the fact that the time is of essence or not, as per terms of contract, court may infer that it is to be performed in a reasonable time. In this judgment, the Honorable Delhi High Court also referred to the Solomon decision of the Honorable Supreme Court in 2001. In A. Aliamal versus 2023, this case observed that Article 54 of Part 2 of the Schedule of the Limitation Act stipulates limitation period for filing a suit for specific performance as 3 years from the date of performance, and in the alternative, when no date is fixed, 3 years from the date when the plaintiff has noticed that the performance has been refused. Section 9 of the Limitation Act 1963 stipulates that once limitation period continues to run, irrespective of any subsequent disability or inability to institute suit or make any application. Very recently, the Honorable Supreme Court, in its Solomon decision on 1/3/2024 in Major General Darshan Singh by LR and another versus this thing, reported it was held that relief for specific causes is especially required. Considering the plaintiff's conduct of making false and or incorrect statements in the claim, which are very motivating, hold the plaintiffs are entitled to the relief of specific performance. The reliance of the respondent on the Solomon decision database in this relates to this application of provision of 17 of the Registration Act. In Section 53 of this, in 1977, the Act 1005 was observed as in fact the respondent therein failed to establish time is of the essence of conduct. In decision with this in under this Honorable Calcutta High Court, a second reported referred to Solomon decision of in 2009 and observed the limitation is a matter of restriction and which has to be strictly conscript. In the light of the above legal principles from the Solomon decision on the fiscal and the implementation of the court is specified carefully. It is found that the trial court decided issue number 1 has to be indemnity in favor of the respondent and the core issue, that is issue number 2, and the additional issue number 1 as to whether the suit is bound by limitations to be seen in Senate trial court correctly on the basis of the plaintiff material and record evidence provisions of law. Further, the other issue as to the entitlement to the degree of specific performance, that is issue number 5, is also vital from the point of view of facts and substance of this case. So far, the findings on the issue number 3 with regard to agreement in question is concerned, it appears that the agreement has been proved at Exhibit 1, whereupon signatures of Pritam Singh has been identified at Exhibit 1 by 1, and that of Exhibit 3, Narayanan Exhibit 1 by 3. Signature of Rajaram as Exhibit 1 by 3. This agreement is a known contention in this case, and in the concurrency needs to be respected of the agreement needs to be referred. Clause of 1 of this agreement contains the interestedness of the seller in the purchases of cells and purchase, and clause 2 contains that is sum of 10,000 has been received as a part in transaction spent of 200 square meters, and out of the 15,000 survey number has been mentioned in clause 1. Clause 3 of the agreement contains the first party, Mr. Rajaram, will fully hand over the land that is outside the second party within 3 months, and clause 4 contains the sellers assure that second party will purchase to take all necessary steps to make it registered in favor of the purchaser. Now, the claim to the respondent needs to be looked into again if the evidence for the agreement in question has been treated correctly because it might be the finance of the other parties issues required reconstruction by the settlement court. The careful perusal of the claim shows that respondent claimed to projecting the fact that P and Mrs. Rajaram are known to each other since childhood, and on this he and Mrs. Rajaram entered into an agreement to sell the and achieve the property survey number this. This is Rajaram mentioning this for a total interpretation of the previous. The response for the projecting case that possession of the property was handed over to him by Mr. Rajaram within 3 months from the date of execution of the agreement. The further claiming on the respondent pending in the claim is that whenever he approached Rajaram to get the sale registered in respect of the suit land, Rajaram told him that he should not be about the registration as sale agreement sufficient to protect his rights. He further averred claim, even when the plaintiff continuously approached Rajaram, once in 2000, the Sarkanaram told the plaintiff that in order to get the sale deed extent, in respect to the suit, sale permission is necessary. He also told the plaintiff that he has applied for sale permission, and once such permission is granted, he will register the sale deed. So in the light of this averment of the claim, when the Provision of Limitation Act in Article 54 of the schedule appended to the Limitation Act is produced, the same specifically provide a period of limitation for filing the suit for specific performance of contract as 3 years, and a limitation to start from the date fixed for performance, or if no such date is fixed, when the plaintiff has noticed that performance is reduced. For the sake of finding the relevant provision is reproduced. There are two limbs of Article 54 of the Limitation Act and the time from which period begins to run. From date fixed for the performance. When a date is fixed, it means that there is a definite date fixed for doing a particular act, but when no date is fixed, the limitation to start from the date when the plaintiff has noticed that the performance of the basis contract is refused. The date of refusal is to be established with reference to the material evidence brought on record. The expression time from which period begins to run in the second line of Article 54 refers to a case where no such date is fixed. If when date is fixed, it means that there is a definite date fixed for doing a particular act. Even in the second part, the stress is on when the plaintiff has noticed that performance is reduced. Here again, there is a definite point of time and the plaintiff notices the refusal. In that case, both the parts refer to a definite dates. The claim of the respondent plaintiff contains vague averments with regard to the date of performance. It is in as much as that it seems to be a clever drafting to somehow make out the case which is otherwise barred by limitation, because of the reason that as per paragraph 6 of the claim, it was in the year 2000 when the performance of the contract dated case was refused by the deceased Rajaram, but the plaintiff somehow tried to put a blame upon deceased Rajaram that he needed to receive the sale deed in his favor. Not only this, in paragraph 7 and 8 of the claim, also respondent plaintiff failed to have a specific date on which he approached deceased Rajaram on his legal rights, and when he refused to perform his public were part of contract related. Even otherwise, if it is taken for the sake of argument, only when the respondent plaintiff waited for performance of contract from the side of the seller till his death on 19/3/2003 and somehow tried to create another cause of action by giving date sometimes in December 2003. Even then, at the best, the cause of action could have been set to start the limitation period from December 2003, though it has been already stated that from the year 2000 as per own admission of the respondent plaintiff. It is an admitted position in law that the period of limitation, once started then shall not stop. Moreover, there is no scrap of document to the side of the respondent plaintiff on the form of file to show if he has served any notice of demand asking the deceased Rajaram or his legal rights within the period of limitation for performance of his contract by him. And there is no admission by the deceased Rajaram legal rights within the period of limitation as a period which shall not stop. In this connection, the provision of Section 9 of the Limitation Act are the users. From the own admission of the respondent plaintiff in the claim, the time to file the suits for specific performance has begun to run at the best from the year 2000, and as per Section 9 of the Limitation Act, no subsequent disability would stop it. No suit was filed within the limitation period of 3 years by the respondent plaintiff, and even the plaintiff is found suffering from distortion, suppression of facts, and that on the one hand, there is a specific pleading by the respondent plaintiff in para 4 of the plaintiff that accordingly, the last week of March 1998, Rajaram handed over the peaceful physical possession of suit land to the plaintiff. Such evidence is not supported by even a single piece of evidence, and 302 as well as a government exhibit A, B, C, release falsify the stand of the respondent plaintiff. Thus, it becomes clear that no possession of the suit land was handed over to the respondent plaintiff by the deceased Rajaram. Though apparent defense have failed to show or prove that the agreement exhibit 1 is a loan agreement or any loan of rupees, this was taken by Rajaram, and in that context, the respondent plaintiff has been able to prove that the agreement in question was a agreement for sale and its registration is not compulsory. When there is a pleading by the respondent plaintiff to the effect that Rajaram was pending to register the city deed in his favor, then legal action could have been taken within the limitation period from which the limitation period of limitation has started to run from the year 2000 itself. Though there is no specific date of refusal by the deceased Rajaram, it is beyond understanding of a man of ordinary prudence that one shall wait for a period of 18 long years for awaiting performance of the agreement by the other side, then there must be a gulf of difference in the prices of immovable property, which is a land in a highway connecting road near to the city. Mere lodging of an NC, that too after a period of 18 years does not give rise to a cause of action which was not in existence at that point of time for filing the suit. There is no specific evidence of the respondent plaintiff that he approached Rajaram all its legal heirs. The written arguments of the respondent plaintiff when considered in the light of the pleading evidence, it's found that the vague explanation has been submitted, which is not supported with provisions of law or cogent evidence, because of the reason that appellants have categorically denied execution of agreement for sale, and as such, the burden to prove that the case was filed and its plaintiff in the period of limitation was upon him. The relief of specific performance is the relief under law of equity and discretionary one, wherein the person who seeks equity must do equity and must come with clean hand, as also is the basic principle in law that the law protects the vigilant and not the dormant. There is no document in the file of the respondent to show that its possession of the land suit like that. The documentary evidence and even the admitted case of the respondent to the Rajana was the owner of the suit to be evidence and the legal evidence. No document has been filed on the court by the respondent to show that he lodged in the case with the revenue authorities for mutation in his favor or against disturbance to his possession, obviously, so because he was not in possession, as it is found from the record. Finding the Learned Trial Court that it was for the defendants to prove that the specific performance refused is not correct. Because the positive case of the plaintiff was to be proved by him only, but Learned Trial Court remained silent on the inaction of the appellant after refusal by deceased Rajaram to perform part of contract in the year 2000 and by his legal heirs appellants in 2003. Thus, the limitation period to record from the year 2000 except the ground of having no mutation has been taken by the respondent plaintiff against the in the lifetime of Rajaram. No such requirement of mutation was there when he was refusing or evading to perform his contract in the year 2000 itself. And then why no action was taken by this contract as such the findings of the Learned Trial Court are also silent on this issue. There's an argument of Learned counsel for the respondent plaintiff on this score are negative. If the plaintiff respondent had been in possession of the suit, then obviously during the course of demarcation, he would have present there and notice of mutation would have been given to him. This ground is found without any substance, and the trial court seeks to normally shift to the owners of proof upon the appellant. In an agreement to sale of immovable property, refund of the amount paid in lieu of decree or specific performance can be awarded after considering the conduct of parties and circumstances of the case under which contract was entered into, if plaintiff unfair advantage over the defendant under circumstances making it inequitable to enforce specific performance. In this case, the respondent plaintiff has also failed to explain the use of item in paragraph 3 of the sale agreement, which is not signed by any of the party to the agreement, meaning thereby that something has been concealed or withheld, which is not explained. Moreover, the Honorable Supreme Court in Chennai explained the principles governing this of the specific legal before its amendment in 2018, which provide the discretion as to declaring the specific performance may not be exercised in the cases where performance of the contract would involve some hardship on the defendant which he did not foresee, whereas its non-performance would involve no hardship on the plaintiff. In this case, the Honorable Court in paragraph 11 held that in our view, the material which has been placed on the court indicates the terms of the contract into the agreement and circumstances under which the contract was extended to give the plaintiff an unfair advantage over the defendants. These circumstances may be inapplicable to impose specific performance. In the case in hand, the specific performance of contract has been solved by the plaintiff after 18 years of the sale agreement, and there is specific covenant in the case that he approached Rajana in the year for execution, but Sri Rajana avoided, and he ought to have filed a suit at that relevant point of time within the limitation period itself, which is not the case here. The finding on the Learned Trial Court are not found to generate convincing unless it failed to consider vital aspect that in a period of 18 years, the prices of any property rising manifold issues on a fact agreement the degree of specific performance by the respondent to should have been decided considered in the case when statement the requisite evidence to shoot the entitlement as well as the issue of jurisdiction and provision of law. It appears that there is no explanation given specific date by the respondent in the claim as to when he approached Rajaram for execution of the debit and when he refused, as well as no action taken during the period from this till this, except when the FIR dated this, whereupon no action has been proved. The direction of the trial court asking the offense to execute sale for a land measuring 200 square meter for a sum of rupees is only that too after a period of 18 years of the execution of sale agreement for sale. Despite contradictory evidence in the claim regarding handing over the position, in my view, involve a grave hardship upon the evidence of the discretion is exercised. While no hardship will be caused to the respondent plaintiff into this direction for refund of the alleged paid amount of rupees along with the interest is paid. As to explanation to section 20 of the specific relief act, the question of hardship has to be determined with reference to circumstances of the case. Moreover, the suit itself is part of the limitation in that situation. Respondent should not be equitable in relief for specific performance. The findings of the trial court in this regard are found not in consonance with the pleadings, evidence, and provisions of law. The cumulative assessment of the evidence on record as well as judgment of trial is found in the trial court is finding upon issue number 2 and issue number 1, as well as issue number 5, has failed to arrive at a logical, legal, and speaking finding. The London trial court has failed to appreciate the provisions of law that limiting as well as also the entitlement of the respondent to the grant of discretionary relief for specific of the contract. And as such, in my view, it has not been decided issue number 2 and additional issue number 1 as well as issue number 5 correctly. As such, findings of the trial court on these issues are found suffering from material irregularity, impropriety, illegality. Therefore, the same are liable to be interfered with in this appeal. But at the same time, consider principles governing the provisions of specific relief act, more specifically provisions of section 20 of the specific relief to award the compensation to the respondent regarding refund of the part payment of rupees 10,000 is given at least at the rate of 9% per annum from the date of payment till the date of realization to the balance of the balance equity. The rate of interest over and above the sum of 10,000 appears to be adequate to compensate the respondent plaintiff towards the payment of rupees 10,000 as claimed by him and not denied by appellant. The higher rate of interest in order as it is not known, shown or proved that the transaction in question was a commercial purpose, and even the prevalent rate of interest by the nationalized bank on the fixed deposit is below 9%. Thus, the rate of interest appears a compensation subject. Your Lordship, conclusion. Your Lordship, the main
Primarily on the limitation issue.
primary limitation, because though the learned first appellate court observed certain things, but the decision is not based upon those things, like issuing of notice, then using of whitener. All these things are not the relevant factor, which is on the basis of which the decision is based. Thing is the limitation, and the learned first appellate court relied upon the averment in the plaint to come to a finding that the plaintiff himself has stated that in 2000, Rajaram has avoided and refused to execute. Now, Your Lordship may kindly come to the plaint.
A page.
It is page number 2. 1 it starts. Page number 2, Your Lordship, the paragraphs are there. I will take, Your Lordship, the relevant paragraph.
Yes.
Now, Your Lordship, the paragraph 6, that Rajaram was working as a PO in Deputy Commissioner's Office, South Andaman. I will, Your Lordship, justify this particular thing, these facts from the evidence also. Rajaram was working as a PO in Deputy Commissioner's Office, South Andaman. Therefore, whenever the plaintiff approached Rajaram to get the safety registered in respect to the suit land, Rajaram told him that the plaintiff should not worry about the registration as sale agreement is sufficient to protect his interest. Even then, the plaintiff continuously approached Rajaram. Once in 2000, the said Rajaram told the plaintiff, but in order to get the sale deed registered in respect of the suit land, sale permission is necessary. He also told the plaintiff that he has applied for sale permission, and once such sale permission is granted, he will register the sale deed. Where is the refusal, Your Lordship? Nowhere a refusal is there. I have not, if suppose, Your Lordship, I have left the paragraph up to this necessary. Sale permission is necessary. Up to that, I have left. I have not stated these 3 lines. It can be presumed that he avoided to execute the sale deed, and in order to avoid, he has taken a point of obtaining of sale permission. I can understand. But, Your Lordship, these 3 lines are very relevant. Specifically, he also told the plaintiff that he has applied for sale permission, and once sale permission is granted, he will register the sale deed. Then, the plaintiff believed Rajaram, and he was satisfied with his reply as Rajaram was working in the Deputy Commissioner's office. Plaintiff thought that Rajaram would have better knowledge about the sale of the land in these islands. However, the plaintiff did not stop approaching Rajaram for getting the suit land registered. That on this, Rajaram expired. After the death of Rajaram, the plaintiff approached his legal heirs sometimes in December 2003 and requested them, because death took place in March 2003, Your Lordship. It is not possible for any person that immediately after the death, the person should approach the legal heirs and ask for getting the sale deed executed. So he waited for some months, at least 6 months, and requested him to get the sale deed registered. As they were aware of the sale agreement between the plaintiff and Rajaram, they assured that they will register the sale deed in favor of the plaintiff. They assured that for about 2 years, the legal heirs of Rajaram did not take any steps on the ground that unless the land is mutated in their name, they cannot register the sale deed. Law is very clear, Your Lordship, in these islands also, we all know that once mutation has to be done, if the names of the legal heirs of the deceased is recorded in the record of rights, then only the registration will take place. Without that, in the name of the dead person, it cannot be done. So they say that once the land is mutated in their name, they will do it. That since the plaintiff has been approaching the legal heirs of Rajaram to know about the progress in mutation, various reasons were assigned to the legal heirs of Rajaram. Plaintiff did not doubt the legal heirs of Rajaram as there were no disturbance to his possession, and it did not appear to the plaintiff and defendants were adopting dialectic tactics. That it was only in the 1st of July 2016, defendants started troubling the plaintiff by asking him to vacate the suit land. Specifically, the month and year is mentioned. And if I am mentioning the date also, Your Lordship, it will not look that this is real. Because remembering a particular date also, it will be very difficult to remember that when he has gone and when they have refused. So the month is written that in that particular month he has been there. And it was in this month that the defendant refused to register sale in favor of the plaintiff and directed him to vacate the suit land. The defendant specifically, the defendant number 1 and 2 tried to demolish the fencing of the suit land, and upon the objection of the plaintiff, they went back. However, they told the plaintiff that they will engage some persons to demolish the fencing and to occupy the suit land. The plaintiff states that the plaintiff has developed the land and raised various fees and plans over the same. Around ₹50,000 has been spent by the plaintiff for the development of the suit land. Now, Your Lordship, the prima facie case and all these things, Your Lordship. Now, Your Lordship, the documents are very relevant.
So the denial was in 2016.
2016, July 2016, as per me, specifically, I have heard that in July 2016, there was a denial. Now, Your Lordship, when I have specifically pleaded this thing, now kindly come to the written statement.
Yes.
Your Lordship, I am taking Your Lordship to paragraph 7.
Yes.
That with reference to the statement made in paragraph 4 is denied and disputed further submitted at no point of time the husband and father of the defendants entered into any sale agreement. As such, handing over of possession does not arise at all. And the further submitted since the plaintiff and the deceased was childhood friend, the deceased approached plaintiff for a loan of ₹10,000. The plaintiff obtained a signature of the deceased in the blank bond paper, and later on, after the death of the deceased, the same has been written down by the plaintiff. So, Your Lordship, signature is admitted. The nature is disputed, but signature is admitted. Now, Your Lordship, paragraph 9, that with reference to the statements contained in paragraph 6 is partly admitted and is denied and disputed. And further submitted, deceased Rajaram was working as peon in the office of Deputy Commissioner. Now, Your Lordship, kindly come to paragraph 13. That with reference to the statements contained in paragraph 11 and 12 are denied and disputed, further submits that suit land is in active possession of the defendant, as the defendants have applied for demarcation of land before the Tehsildar court there, and notice dated this, and this was issued to defendant number 1 and neighboring plot holder. Your Lordship, this is very relevant. 2003, Rajaram died. From 2003 to 2015, they have not taken any steps. It appears from paragraph 13 to get the land demarcated and to get the land mutated in their names. It was only in 2015 when they are submitting an application for demarcation of the land. Your Lordship, demarcation is very important. Demarcation is done generally when you don't know where is the boundary.
The difficulty is the first appellate court has not dealt with these issues at all.
Not dealt.
Has only dealt with the limitation point.
But Your Lordship, the trial court has dealt. Trial court has dealt everything. All these, when this happened, when all these things and all the documents, everything was trial court. If Your Lordship will see the trial court's judgment, Your Lordship will find the answer. All issues have been answered. So, Your Lordship, this particular thing, demarcation application was made in 2015 only. And when they started, when the Tehsildar demarcated the land, after demarcation of the land, when they came to know the boundary of the land, they tried to demolish the fencing. At that relevant point of time, I reported the matter to the police authorities. So how can we imagine that the cause of action has arisen prior to that? This limitation, Your Lordship, it is very clear. There are several judgments of the Honorable Supreme Court, Your Lordship. We know in a case of specific performance, Your Lordship, there are divergent views. One judgment says one thing, another judgment says another thing. But Your Lordship, one thing is very clear, that time and again the Honorable Supreme Court has said that in a suit for specific performance of contract, time should not be considered to be the essence of the contract. And if no time is prescribed, then facts and circumstances have to be looked into. Hardship has to be pleaded and evidence has to be laid that what hardship is getting caused to the other side. So far as myself is concerned, after paying rupees 10,000 to him, that my hardship is clearly shown that I have paid the amount. But what is your hardship? Nowhere in the written statement it has been stated that why they don't want to execute the sale deed, what type of hardship would be caused to them. Nothing is mentioned. No, Your Lordship. On 16/6/2016, demarcation was done and report was filed by the Patwari concern. It is the afterthought of the plaintiff that NCFI has been chalked out by the plaintiff against the defendant. Why immediately after this, Your Lordship? If the plaintiff's intention is to create a cause of action and he wanted to file or lodge a complaint before the police authorities to see that a cause of action is created and he can file it for specific performance of contract, then why immediately after demarcation he will do that? He could have done it after that or before that. This itself shows, Your Lordship, up to 2015, there was no problem between the party. They said once mutation is done, they will register the sale deed. Mutation took place in 2015. 2016, they sought for demarcation. When they tried to demolish the fencing, I reported to the police authorities immediately. And then, when did I file the suit? Your Lordship, 14/7/2016. Your Lordship, within a month, I filed the suit, Your Lordship. When the demarcation took place and when they tried to demolish the fencing, within a month, I filed the suit. So where is the question of limitation? Now, Your Lordship, I will take Your Lordship to the deposition, Your Lordship.
The sale agreement has been executed.
Yes, without, just so far as I remember. Yes, it has been executed. Exhibit 1. Sale agreement was exhibit 1. It was with objection, but signature of the plaintiff.
That is admitted.
Plaintiff also, plaintiff. Admitted and that is without any objection.
Because they say it was a blank page.
Yes.
So the signatures were admitted.
Now, Your Lordship, kindly come to the cross-examination of W1. Page number 34.
13/1/3.
3/4, Your Lordship.
34, yes.
Yes. Now, Your Lordship, skipping for 5 lines, Your Lordship. After the execution. After the execution of the said deed of agreement and before the demise of Rajaram, I did not send any legal notice to him requesting to execute a registered sale deed in my favor. Your Lordship, in my opinion, this particular question goes against the defendant. Because by asking this question, you are admitting that agreement has been executed. You wanted a notice to be issued to Rajaram. If the notice was so much important as it is important as per 106 of the TP Act, Your Lordship, then the question would have been completely different. Here, Your Lordship, under the specific relief act, there is no provision whereby one has to issue a legal notice or a notice in writing. That notice word is knowledge, that information. At the end of paragraph 3 of sale agreement, Whiteman has been used to arrest this. I'm not. Now, Your Lordship, after 2-3 lines, on the day of agreement, kindly come to that, Your Lordship, just second page. On the day of agreement, possession of the suit land was not handed over to me. The possession was given after 3 months. This is coming in the cross-examination. After obtaining possession, I did not send any legal notice to Rajaram asking him to execute proper sale deed in my favor in respect of the suit property. Rest, Your Lordship, these are not so important because I did not submit any document to show that I am in possession of the suit land. Then the distance between the house of Rajaram and my house is 200 square meters. I am acquainted with the news of his death. After the death of Rajaram, I did not issue any legal notice to his legal heirs, being the defendants, asking them to execute the proper sale deed in my favor. I studied up to class 12 and I was a government servant. I was attached to secretariat. I did not publish anything about death anniversary of Rajaram in any newspaper. It is not a fact that Rajaram did not execute sale agreement. In the sale agreement, the schedule of the said land has not been mentioned. It is not fact that Rajaram never promised to sell any land to me. It is not a fact that I never approached defendants to execute sale deed in my favor. It is not a fact that signature of Rajaram is not appearing on the sale agreement. Presently, the suit land stands in the name of all the 3 defendants. I never made any application with regard to that. These are not relevant relations. No, yes, I never made any application before the Tehsildar after the death of Rajaram requesting not to do mutation in the, why should I do that? Because only after mutation, the sale deed can be executed in my favor. I cannot object to the mutation. Rather, I should assist them to get the land mutated in their name. Then only in my name it can be registered. Then it is not a fact that I was never in possession of the suit land or the defendants are in possession of the same. My own land is also situated beside the suit land. It is not a fact that I never made any payment to Rajaram. Not a fact that I am not entitled to the suit land as per agreement is. It is not a fact that NCFIR this was lodged on the basis of falsehood. My worship. Page number 37 is the ROR and sketch map, Your Lordship, through the Tehsildar. It was brought on record and those were exhibited. That is, which shows that the defendants are presently the recorded owner of the suit land.
Two things. If you're able to substantiate the limitation ground, the matter has to go back because the other points were not considered at all. It was only on the ground of limitation that the appeal has been dismissed. And if you do not succeed, the secondary.
Yes.
So these are the primary grounds.
Lordship, sometimes, Your Lordship, there are certain decisions that if Your Lordship can look into the trial court judgment, Your Lordship, trial court has dealt with all those things, then the remand is not at all necessary.
We need to go through the trial.
Yes. No, just I will, only 2-3 witnesses are there. I'll just complete and I will go to the trial judgment. Your Lordship, the next one is Narayan Lal, who is the witness, attesting witness. Page number 46, Your Lordship. What is chief in
46, yes.
Now, peculiar thing is that, Your Lordship, here there is no objection with regard to the marking of the signatures of Rajaram. Now, Your Lordship, rest, Your Lordship, I'm just placing it. I did my study till this. I was studying in Hindi medium. I a very short cross-examination in there. I acquainted with Rajaram and Pritham Singh since my childhood. I received a summons from this court to depose in this. So this is a summons. Exhibit 1 is shown to the witness. Below my signature, there is not mentioning of my father's name, my residence, and the date on which I signed the document. Whether after 3 months from the date of execution of the sale agreement, the possession of the suit land was handed over or not, or any further payment was made or not, are not mentioned in the document. Rajaram died in the year 2003. It is not mentioned in the document he has stated. Rajaram died in 2003. I do not know whether any notice has been served upon Rajaram by Pritham Singh during this to this. I do not know whether after the death of Rajaram, any notice was served upon legal heirs of Rajaram or not by Pritham Singh. I do not know whether any paper publication was done regarding the purchase of suit land by Pritham Singh. The sale agreement is not notarized. It is not rest. It is not a fact. The only thing is that, Your Lordship, after 3 lines, when the possession was handed over to Pritham Singh, I have not signed any document. Rest everything, it is not a fact. Now, Your Lordship, may kindly see one thing. The only thing, Your Lordship, it is that in the examination in chief about possession, he has specifically mentioned. Paragraph 5 of the examination in chief, page number 43. I'm just placing, I say that Rajaram agreed and handed over the possession of the suit land to the plaintiff within 3 months from the date of entering into the sale agreement. Along with me, Premlal was also present when Rajaram handed over the peaceful physical possession of the suit land to the plaintiff. There is a denial and in the last, but Your Lordship, so far as the presence of Premlal is concerned, Your Lordship, at the time of taking over the possession, I don't think that any specific denial is there. Rather, Your Lordship, this particular sentence also, I feel it would go against the defendant. When the possession was handed over to Pritham Singh, I have not signed any document.
Yes.
Now, DW1 Your Lordship. DW1 Sandhya Rani. Cross-examination, page number 54. Your Lordship. I have seen the documents filed by the. Yes, I have seen the documents filed by the plaintiff. Your Lordship, this is very important because she saw the documents filed by the plaintiff. I have seen first line, cross-examination, page number 54. I have not seen the agreement dated this filed by the plaintiff in this suit. In the beginning, she says documents have been seen. Then she says, I have not seen. Only after seeing the document, I can say whether the document was signed by my husband or not. This is highly irrelevant because signature is not disputed. I have not stated that the plaintiff managed to obtain the signature of my husband. This is very important. All along the case of the plaintiff defendant is that the plaintiff managed to get the signature of the husband of the defendant number one. And practically it was a document relating to some loan, and on the blank bond paper signature was taken. Now she has specifically stated that I have not stated that the plaintiff managed to obtain the signature of my husband. I do not have any knowledge regarding the sale agreement dated this. My husband was a peon in DC office. My husband died due to heart attack. It is not a fact that my husband agreed to sell the suit land to the plaintiff by entering into an agreement on this and received an amount of rupees as advance. I do not know Narayana. It is not a fact that December 2003, the plaintiff approached her for registration and execution of the sale deed in respect of the suit property. The mutation of the suit property was done in our name in the year 2015. It is not a fact that again in the month of July 2016, the plaintiff approached us for registration and execution of the sale deed in respect of the suit property. The plaintiff had lodged one police complaint against us, and for which one NCFI was chalked out against us. I have two children. My son is in service at DC office, and my daughter has got married and now residing in an in-laws house. My house is situated at a distance of 1 kilometer from the shop of Nandi's store and Sampath store. The survey number 501 belongs to one Tamilian. We have applied for the demarcation of suit land before the Tehsildar either in the year 2015 or 2016. It is not a fact that we applied the demarcation of the Tehsildar in order to grab the suit land, and for which the plaintiff lodged the NCFI against us. The suit land was allotted to Rajaram by the administration. It is not a fact that suit property is in possession of the plaintiff. The suit property is situated at a far distance from my house. So this is also very relevant, Your Lordship. How they were telling that they were in possession, because it has been, I just read that particular cross-examination, that this land in question is my land, the land which is recorded in my name, that is situated just beside the suit land. And they are residing 1 kilometer distance from the suit land. The house where I am residing belongs to my husband's grandfather. We are residing in the said house since last 37 years. The suit land was allotted at the time of birth of my daughter, and I came to know the sad fact at the time. She was born in the year 9. We are not residing in the vicinity of the suit land. Police called us after lodging NCFI by the plaintiff. Police asked whether any dispute arose or not. We told the police that no such dispute has arisen in between us. Police authority told me the plaintiff alleged in his complaint that we had removed the fence of the suit property. Now, Your Lordship, she is accepting that police authorities have told her that they have removed the fencing from the suit land. It is not a fact that people say develop the suit land. It is not a plaintiff is entitled to it. It is also a file examination sheet. I'm deposing falsely. Now, Your Lordship, page number 57 is the evidence from the Tehsil office. He want the documents relating to the demarcation of the land and mutation of the land was exhibited through the defendant. Now, Your Lordship, I kindly see here the cross-examination is important. Whenever an application is submitted for demarcation of the authority, verify the survey number and the recorded tenant, and notices have been issued to the recorded tenants as well as to the adjacent plot holders. Thereafter, surveyor visits the spot and shows the boundary of the land to the recorded tenant. I cannot say whether the suit land was vacant or there was some construction at the time of demarcation. It is not written in the compliance report that Sandhya Rani was in possession of the suit land at the time of demarcation. I also cannot say, even after seeing the compliance, who was in possession of the suit land at the time of demarcation. No notice was issued to Pritam Singh for demarcation of the suit land. Surveyor cannot ascertain as to who is in possession of the suit land. If someone applied for demarcation, if the surveyor found that someone else is in possession of the suit land, he can mention the setback in his report. He cannot mention in his report if the land is vacant land. So the land was a vacant land. So they tried to get the land demarcated. When they came for demarcation of the land, as it was a vacant land, they cannot find, Your Lordship, the plaintiff in that particular land. It is not possible to find the plaintiff there in the vacant land. And these people have applied for the demarcation. So when the notice was issued to them, they knew the date and the time of demarcation. So they were present at that time. Even after that, Your Lordship, in the demarcation report, nowhere it is written that Sandhya Rani has been in occupation of the property. So that was not the issue, and might be that is the reason it was not taken. No, Your Lordship. That's the reason. Your Lordship, lower court records are there, Your Lordship. One, the NCFIR, Your Lordship, can be looked into once.
Page 62 really other.
वो आधा है इसीलिए तो lower court record.
You are referring to which document?
Page 62, my lord.
62, Your
Last
Lordship.
portion is given in the paper book. Page number 62.
थोड़ा आप मेरे को दीजिए ना, मैं लोकेट करके दूंगी. It will be easy for the court to see.
This is the FIR, copy of the.
NCFI.
NCFI.
This is half portion is there, my lord.
Yes, the later portion is.
Yeah.
विषय का आगे बढ़ेंगे.
Yeah, didn't.
वही तो आगे फिर फ्लैग कर दी.
First page is missing.
First page is.
You are complete.
हाँ. ये थोड़ा दे दीजिए. फ्लैग किया, फ्लैग किया. फ्लैग.
Yes.
I'm just taking it, Your Lordship, from Shri Vikram Singh, son of Shri Ram Singh, Border Crescent, South Andaman, to his station house officer, P.S. Against South Andaman, complaint against Sandhya Rani, wife of Latif, and Shri Sudeep Ram, son of Latif, both are residing at Sipiga Junction, near Nand Kishore and Sampat Store, Border Crescent, South Andaman. Sir, I have entered into a sale agreement with Rajaram in respect of land bearing survey number registration with Shishwari, under Border Crescent, South Andaman. After entering into the sale agreement, Rajaram handed over possession of the land in question to me. I occupied the same and invested huge amount of money. I approached Rajaram, and after his death, we legalized on several occasions to clear the sale agreement, but one on ground or another they delayed. Few days before, legal heirs of Rajaram, Srimati Sandhya Rani and Shri Sudeep Ram, tried to demolish the fencing of the land in question to occupy the same illegally. With the legal heirs of Rajaram have a right in respect of the land, they can approach the court of law, but they cannot forcibly and illegally enter upon the land with an intention to harm the property and occupants. I refused them to enter upon the land, to which they told that they will bring unsocial elements on the next time to occupy the land in question forcibly. They also told that they will not think twice before inflicting injury to me and my family members. I am in a difficult situation and require immediate action against Srimati Sandhya Rani and Shri Sudeep Ram. I therefore request your person to kindly register an FIR against Srimati Sandhya Rani and Shri Sudeep Ram for illegally attempting to destroy my property, threatening me to harm me and my family members and to occupy the land in question forcibly. So, Your Lordship, immediately after that, the NCFIR was lodged when they tried to, this demarcation took place, Your Lordship. In the demarcation, when they tried to demolish the fencing, I lodged the FIR. Now, very good. So, Your Lordship, my submission is that the first appellate court has not considered those aspects, Your Lordship, because mainly the point of limitation was considered. So far as other points are concerned, Your Lordship, I cannot argue at this stage because those points have not been considered by the first appellant. The trial court, Your Lordship, has discussed the entire thing. That trial court judgment, Your Lordship. 19. Starts from page number 92. Please. Now, Your Lordship, the first issue number 1 and 2. That is with regard to maintainability, Your Lordship, I am not placing that one. Because that is not an issue with regard to the maintainability of the suit, Your Lordship, the waiver, acquisition, estoppel, and all these things are not there. Now, Your Lordship, issue number 3 and 6, that is important. These issues are taken up together for brevity and precision, since these issues are interrelated and interdependent upon, and also for the purpose of avoiding the repetition of fact. The issue of limitation is a mixed question of law and fact, hence the issue also taken together for brevity and for convenience of discussion. It is pertinent to mention here that the argument as advanced from the side of defendant is based on the law points and not on fact. However, the court has to decide as to how far the plaintiff has been able to prove his case. It is the cardinal principle of law that plaintiff has to prove his case at his own strength. It is further stating law that absence of defendant or defense would not benefit the plaintiff in any way. As per the plaintiff, on 24/12/1998, sale agreement was entered between him and the said Rajaram, whereby deceased Rajaram agreed to sell the suit land to the plaintiff for a sales consideration of ₹15,000 and plaintiff paid ₹10,000 as advance, and it was agreed that the Blair payments amount of ₹5,000 shall be paid by the plaintiff to the said Rajaram at the time of registration. In order to substantiate its contention, the plaintiff has produced the original sale agreement dated this, which was marked Exhibit 1, and signature of the plaintiff was marked Exhibit 1 by 1. Having produced the agreement for sale dated this, it appears the sale agreement was executed in between the plaintiff and Mrs. Rajaram in respect of the land, measuring 200 square meters, bearing survey number is situated at this. It further appears that the first party received ₹10,000 as part payment, and balance amount of ₹5,000 will be paid given by the second party on registration. It was agreed that the first party will deliver the possession of the suit land to the second party within 3 months. It was further agreed that the first party will take all necessary steps to make it registered in favor of the purchaser. Section 68 of the Evidence Act provides that if the document is required by law to be attested, it shall not be used as evidence until one attesting witness at least has been called for the purpose of proving his execution, if there be an attesting witness alive and subject to the process of the court and capable of giving evidence. And Section 68 of the Evidence Act lays down a mode of proof and not quantum of evidence required. The person attesting must have been seen the executor sign or obtain his personal acknowledgement of execution from executing and thereupon signing the present executor. In the instance, the plaintiff had used one Narayan Lal as a witness to this suit to prove the validity and genuinity of the evidence for sale. With this, as it is contended by the plaintiff as Narayan is the attesting witness of the said agreement. I'm just pausing for a moment. So far as establishing the existence of the sale agreement and proving of a sale agreement, so as per Section 68, in order to prove a sale agreement, attesting witness need not be examined. It is only in the case of gift and will. For sale agreement, Your Lordship, not at all required. Even then, Your Lordship, Narayan Lal was brought because they were disputing the existence of the sale agreement. Instead, Narayan Lal in his examination, he deposed that he was the witness of the sale agreement along with another person namely Premla. He further deposed the plaintiff Pritham Singh, and this is Rajaram had put their signature in the said sale agreement. Dated this in his and Premla's presence. During testimony, he identified the signature on the agreement of sale dated this, which was duly marked as Exhibit 1/2. The PW2 was duly cross-examined by the counsel for the defendant, but during cross-examination, he remained firm and his testimony was shaken. On the other hand, the defendants in their statement challenged the validity and genuinity of the agreement dated this. Defendants submit that since the plaintiff and the deceased Rajaram were the childhood friend, the deceased approached plaintiff for a loan of ₹. The plaintiff obtained the signature of the deceased in the blank bond paper, and later on, after the death of the deceased, the same has not been written down by the plaintiff. Surprising to know that during the argument, the counsel for the defendant did not submit anything regarding the genuineness of the agreement dated this. The PW1 named Sandhya Rani during a cross-examination deposed that she does not state that the plaintiff managed to obtain a signature of her husband in the agreement. Hence, it goes without saying that the execution of the agreement for sale dated this was admitted by the defendant side. During argument of this suit, the counsel for the defendant advanced the argument on the point that his argument is twofold. That is, since the agreement for sale is not registered document as per provision of section 17(1)(a) of the Decision Act. This, the plaintiff is not attacking to with any degree. And number two, since no service of notice demanding the execution of sale was ever made by the plaintiff, the suit is barred by limit. Besides the first one, I'm skipping this, Your Lordship, because this is relating to registration. The law is, by this time, it is settled, Your Lordship, only in Uttar Pradesh, Your Lordship, the amendment has taken place. So far as section 49 of the Registration Act is concerned, that sale agreement is required to be registered in order to produce the same as an evidence in a case of specific performance. So, and another part of India, Your Lordship, that amendment has not taken place. Tamil Nadu state, Your Lordship, they tried to introduce in the rules that registration aspect, but that has been set aside by the Honorable Supreme Court. So, Your Lordship, this I am skipping about registration. And now, Your Lordship, page 12, Your Lordship, the next defense. This is the point of limitation.
Yes.
The next defense that has been taken by the learned counsel for the defendant is that the present suit is barred under the law of limitation. Article 54 of the schedule of the Limitation Act 1963, which governs the case, provides for a period of 3 years for a suit for specific performance of agreement to be filed. If a date is fixed for the performance, the period of 3 years is to run from such date. If there is no date fixed, the period of 3 years would run from the date when a specific performance was refused or the plaintiff had notice of such refusal. Having produced the documents on record, admittedly appears that no date was fixed in the agreement for say for execution of the deed of conveyance, and it is the second limb of Article 54 which would apply in the instant suit. It is a settled position of law that limitation is a matter of description, and accordingly, same has to be strictly construed. A time a barred action is not permitted under the law of limitation and deserves dismissal on the point of limitation. In cases of specific performance of conduct, demand of registration should be made on the part of the buyer, and when it is refused, the cause of action arises. There is no hard and fast rule that notice should be given in writing. So here that aspect also has been covered. Now let me scan the evidence on recording order to decide whether the present suit was filed within the period of limitation or not. As per the plaintiff, whenever he approached Rajaram to get a sale registered in respect of suit land, Rajaram told him that he should not worry about the registration as sale agreement is sufficient to protect his interests. He used to approach Rajaram for registration continuously. In the year 2000, Rajaram told him that in order to get the sale registered in respect of suit land, sale permission is necessary. And he applied for sale permission, and once the sale permission is granted, he will register the sale deed. Admittedly, on this, Rajaram expired, and as per the plaintiff, after his death, he approached legalized in December 2003 and requested him to register the sale deed. They assured the plaintiff that they will register the sale deed in their favor and told them after mutation of the land in their name, they will register the sale deed in favor of him. Thereafter, they did not take any steps on the ground that unless the land is located in their name, they cannot register the sale deed. The plaintiff further submitted that in the first week of July 2016, the defendant started troubling the plaintiff by asking him to vacate the suit land and also refused to register sale deed in favor of the plaintiff. Further, as per the plaintiff, when the defendants tried to interfere with the position of the plaintiff has lodged a complaint before the police authorities, and NCFIR was also chalked out against the defendant. In order to support his contention, the plaintiff produced a copy of NCFIR lodged by him before answering bench placed against the defendant. The NCFIR being named this was duly marked as Exhibit 3. In the said NCFIR, it has been held alleged that legal heirs of Rajaram, Srimati Sandhya Rani Sudipram tried to demolish the fencing of the land in question to occupy the same illegally. During cross-examination, DW1, namely Sandhya Rani, admits the defendant has lodged one police complaint for which one NCFIR was chalked out against them. Having heard both sides on the refusal of the material, it is admittedly appears to this court that the demarcation of suit land was held in the year 2015 among the legal heirs of deceased Rajaram. Plaintiff produced one official witness from the office of president who is condemned the land was located in the name in the name of present defendants. PW2, namely Loganathan, who was also authorized by Tehsildar Portbay Tehsil to depose in this behalf, stated that previously it was recorded in the name of Rajaram, thereafter it was quoted in the joint name of Sandhya Rani, Sudipram and Kavita Rani. He has also produced the ROR and search map of the suit land, which was marked Exhibit 4 and 5. The defendant DW1, namely Sandhya Rani, during her cross-examination, admits that they had applied for demarcation of the suit land with Tehsildar either in 2015 or 2016. And she also deposed that limitation of the suit property was done in the year 2015. Having produced the documents on this one, it appears that the land in question was vacated by the Revenue Authority in the year 2015 by a revenue case under this. Official witnesses from the side of defendant during cross-examination deposed that no notice was issued to preferencing for demarcation of the suit land. It is a settled position of law that the defendants have declined the execution of the conveyance sometimes prior to 3 years before the institution of the suit. It was for the defendant to assert and establish such facts in course of the evidence. Having produced the evidence on record, it appears that there is no cogent evidence on behalf of the defendants on such accounts. It was a similar matter, Your Lordship, arose before this honorable court in another matter. And exactly the same situation arose. That if the limitation point is to be taken, that limitation point has to be taken specifically in a specific manner. Here, they have disputed the execution of the agreement itself. So there is no question of approaching, not approaching, and all these things they will deny only. Admittedly, the demarcation of suit line was held in the year 2015. And after demarcation, suit line was mutated in the name of the present defendants. Before that, the land was recorded in the name of Mrs. Rajara. As per the local regulation, it is only after proper demarcation one can obtain permission to sell his land. Hence, in my opinion, a considered opinion, the suit is filed well within the period of limitation. Moreover, in the absence of any material to the contrary being produced in evidence from the side of the defendant, there is no merit in the point of limitation. In the light of our one discussion as to the facts and law, this court comes to the plaintiff has successfully proved these contentions of the suit. And on the other hand, defendant miserably failed to negate the claim of the prisoner. Hence, this court is of the opinion that the plaintiff's case are liable to be allowed. Accordingly, all the issues are admitted. Now, you notice the point of hardship. That was not taken in the written statement. That was not pleaded. That was not averred. That was not deposed. How the court will deal with the point of hardship? The first appellate court, without any material on record, your lordship, was dealing with the point of hardship also. Though the decision is not based upon hardship, but he was dealing with that issue. So, your lordship, my submission is that, your lordship, the appellate, and I have certain decisions, your lordship, of the Honorable Supreme Court. Your lordship, may I place it tomorrow, your lordship? Tomorrow, very good. Tomorrow, all decisions will be placed, your lordship, and I will place.
Will you come back tomorrow?
My lord?
Will you come back tomorrow?
Yes, my lord.
Third learned counsel for the appellant. Very good.
I request my sister to kindly supply me the copy of judgment so that I
Let
can
me
also.
give the citations.
Please give it to him by today so that he can.
Yes,
send
yes,
it
all
back tomorrow.
citations I will.
Yes,
I'm
so that
grateful.
we can conclude tomorrow.
Yes,
My lord, my lord.
and same. हमारा भी जो है उनको दे।
Citations.
Citations.
Matter is adjourned for the day
Citations sir check.
and let the matter appear under the same heading on
पूरा spiral रखा
30th June.
है।
Tomorrow.
Yes.
I'm handing over my citation.
I will.
अब मेरा तो समझता था देखे हमें बहुत
Yes, next one.
Item number 12, WPS 360/2024 with item number 13, WPS 360/2024.
Yes.
Matters over my seniors for the petitioner. Pleadings are complete. We filed our affidavit in reply. Copy is this matter can be taken up for hearing.
Who is appearing for the respondent?
Sivabalan sir is appearing. Pleadings are complete.
Who is gone?
Come tomorrow, madam. For the heading only.
None appears for the respondents.
My lord, my senior is appearing on behalf of official respondent. Not today, madam.
Learned counsel for the respondent seeks accommodation. The matter is adjourned for the day.
Affidavit in reply that may be taken into.
Today you have given?
Yesterday itself we filed in the registry. Affidavit in reply.
Has it come? Affidavit in reply, first line should be affidavit in reply filed by the appellant is taken on.
Writ petition.
Oh, this is a WP, wait, edition. Next.
Obliged.
Obliged.
Item number 14, WPS 7/2024.
My lord, I'm appearing for the respondent, my lord.
Yes.
Here I am seeking interest upon the delayed payment of the pension, retirement penalties. कुछ नहीं कर सकते, कोई विधि नहीं हो सकती।
A report was called for from the respondents, I believe.
Yes, your lordship.
Disclosing the amount paid to the petitioner on account of leave. It's on leave encashment.
Leave encashment, gratuity, all retirement leaves, your lordship.
My lord, actually, Mr. Kumar, Rakesh Kumar, who's appearing with me, my lord, he has the report, my lord, but I can't see him in court.
No, he's not yet.
If it can be kept for tomorrow, my lord, then tomorrow I can.
These are your affidavits.
Affidavit in opposition is there, but what my lord is saying that
What's
there
called
was
for?
a direction to produce a report, my lord. He's carrying the report, my lord, but he is not in court right now. My lord may just have it tomorrow, my lord. Tomorrow he will be present, my lord.
Learned counsel for the respondents seeks to submit the report as called for tomorrow. Paragraph, the matter is adjourned for the day.
My lord.
Next.
My senior appears for the response.
My senior is for the appeal. In this matter, a coordinate bench of this court directed appellant to increase Tahsildar deputy commissioner as a party respondent in the present. They have taken steps, my lord. I'm just praying for Friday. We will file affidavit of service to that effect. We already dispensed.
I'll just go through the
Yes,
file.
yes.
Since service upon the added respondents is not complete, comma, let the matter stand over till
Right.
first August.
Amrit.
Item 16, WPAP 44 of 2025. In this matter, my senior for the writ petition of this bench directed the respondent to file their affidavit in opposition.
My senior is appearing on behalf of official respondent, my lord, and
Yes.
seeking time to file the affidavit of opposition.
When did you file?
2 weeks, my lord.
2 weeks, another 2 weeks. You already got 2 weeks. File within a week.
Published.
Learned counsel for the
Deepanita Halder.
respondents seeks extension of time to use the affidavit in opposition as sought. Paragraph, affidavit in opposition be filed within a week from date.
Published.
Affidavit in reply, comma, if any, comma, be filed within a week thereafter. Paragraph, the matter be placed before the next available circuit bench.